Yes.
For delivery of judgment, item 1.
Very, very. This is slightly different from the current trend, but we have said in a recent case of so-and-so, the Honorable Supreme Court has clarified that the order of termination of services of an employee, even if on contractual basis, which has been passed on account of alleged misconduct without following the principles of natural justice, the termination order being apparently stigmatic, cannot be sustained without observance of the principles of natural justice. Seen from this angle, we find it expedient to set aside the judgment of the learned single judge and to direct that the appellants be reinstated in service within 3 weeks of passing of this order. And in case the respondents wish to proceed against the appellant, it would be open for them to do so afresh after complying with the due process of law, including adherence to the principles of natural justice, in which event it would be open for the state to take further consequential action in the matter. And then we have given the details. Though notwithstanding the fact that there was a contractual stipulation that he could be terminated, but considering the present day trend, when it is stigmatic, it is not proper. This is what I have said because there was an earlier judgment rendered by me. Oh, sorry. No?
Adjournment request, if any, from item number 2 to 7.
My lord, I have a request for item number 5, my lord. I mean, newly engaged now.
Item number
5.
Item
With the
number
consent of
5?
other side, yes.
Okay.
So, my lord, can I pray for 25th of?
Some person was appearing.
Yes, yes, yes.
person.
The NIT case, my lord, yes.
Mr. Day.
In person.
Huh?
In person. He was personally given on the last occasion.
But he is
But he
engaged.
has been newly engaged, Lord.
We have been
You
newly
have been engaged for
Yeah.
the appellant.
For the
Yes.
appellant.
That's on a very short issue. What do you want?
My lord, let him fix
The
either.
petition is pending.
Yes. Either on 20th or 25th, my lord, any date. We'll give the list of date and other details.
Can I have your name, please?
My name is R.P. Sharma.
Mr. R.P. Sharma. Mr. R.P. Sharma, let us senior advocate. Praise for time in the above matter on the ground that he has only been recently engaged to argue this case. Let this matter, along with WPC number 4378/2024, be listed for consideration on. We have to give you in December, not before that.
Can it be, my lord, on 25th, my lord, if possible?
On
25th,
25th of November.
my lord?
25th of November.
November.
No. That's not possible. So we can give you second week. Sometimes from 8th to 12th of December.
After
Choose
12th,
your
Lordship.
date.
After, after 12th of December, Lord.
After 12th, then this bench is not available.
Then my 9th
We
is.
keep it on 18th of December.
18th of
18th of December, it's a short. All right.
All right.
Any other matter?
From item number 8 to 13, adjournment request.
Item 12 to 14, my lord. I seek adjournment for 2 weeks, my lord.
12 to 14.
12 to 14.
11, nobody has mentioned, no? 12, 13, 14, individually, you write, adjournment slip has been circulated on behalf of the respondent. There is no real objection for grant of time by the appellants. Appellant applicant. Let this matter come up for consideration on January, sometimes in January. Yes,
Public.
20th January.
yes,
Adjournment request.
May it please your lordships, taking consent from the other side, I beg to mention item number 11 of the daily
all
list.
right, adjournment slip hasn't circulated, same order, January.
27th January.
Much obliged, your lordship.
From item number 15 to 26, adjournment request.
Item number 19, Mala, I was told by Mr. S.C. Talukdar, standing counsel, he's not well today, my lord. So maybe taken any day, my lord.
Item number 19.
19. Any day, my lord.
This is with respect to cooperative department.
Yes, my lord.
service
So,
schools.
yes, my lord. So, my lord, S.C. Talukdar, he is not well today, my lord. He was asked me, my lord, told me that he's not well today.
All right. As grateful on behalf of the respondent, re-notify January.
29th January.
My lord, one mention, my lord, for listing, my lord, for appeal, my lord, for admission.
Let other
Okay.
adjournments be done.
Obliged.
He'll call out. Yes.
Wait, please. No, I beg to mention item number 18, my lord.
Item number,
18, 1-8.
this is again rules of 2018 under charge.
Yes, ma'am.
Why do you want time?
My lord, here, my lord, actually, I have not,
Come this side.
since I'm mentioning all that, I'm not,
Doesn't matter. You mentioned from your position.
because my lord, I'm not prepared today, my lord. That is why I'm.
You're not prepared today. All right. Then that's a good ground. Mr. Patania, learned advocate for the respondent, seeks some time to get ready in the matter to address this court effectively. January again. These are
29.
very, very unfortunate ROP rules of 2017. You have to find out what is to be done about it. This is about nurses who are degree holders and diploma holders. The difference in pay. You have not read at all.
I have read, my lord, in fact,
But you're not nodding your head when I'm talking about the subject matter. Is that the same matter?
no, my lord, this is regarding the promotion of headmaster.
Promotion of headmaster.
Yes.
All right, January.
29th January.
Obliged.
Any other request?
Lordship, I beg to mention a matter. If Lordship remembers the probate matter, your Lordship.
Hmm?
Amendment of the Court Fees Act of 1870, your
Yeah.
Lordship. Lordship had directed that we shall be allowed to deposit a fee of rupees 11,000.
Yes, we had said.
Subject to final outcome of the insurance
Yes, we
appeal, your
remember.
Lordship. So we have approached the learned court below, your Lordship. There we have deposited the court fee, but the learned judge there is not willing to grant us the probate, your Lordship, stating that the IA is still pending adjudication, your Lordship.
Oh, that's on a different issue altogether. This was with respect to court fee. We have not adjudicated on that account.
Otherwise, it is set aside, Lordship.
You file, whatever is done, that's on merits of the case. No, he sets aside only for the reason that it has been maintained, the court fee has been accepted. So that's not pursuant to anything that we said.
Lordship, but the probate is not being granted, Lord.
That's different. No. Court fee, you ask the advocate who addressed the court, you ask him and then come with necessary IA or something.
Lordship,
We are not here to advise you.
Lord.
May it please, Lordship. Because I am paying for listing the matter Lordship, from hearing list to another bench, Lordship. My Badajas is allowed this repetition.
You are only making gestures. We are not understanding what is the matter.
Lordship, I think in hearing list, Lordship, item number 118, that may be fixed in another bench, Lordship. Because learned Badajas has passed the repetition.
Part 2 hearing list. Let it be called out. We'll have it listed.
Lordship, in another bench.
This
Lordship.
bench can't hear.
Yes. Lordship.
All right, we'll do that. Tell the- Naturally. Otherwise, the registry, tell the registry. All right,
Lordship.
May I please, your
give the
lordship?
number. We will have it done at the level of registry only. No judicial order is required.
May I please, your lordship? We have filed a writ appeal along with an IA for condoning delay of 24 days. Can it come up on Monday, lordship?
Yeah, it can. Monday.
Obliged.
May plus मतलब one new writ appeal मतलब filed on 10/11. मतलब Friday मतलब there is the urgency मतलब the settlement is
What is the urgency?
the settlement will be going to be held on Monday, next Monday मतलब,
Settlement of what?
or fishery. So writ appeal मतलब we have filed.
No,
Again,
no, you were a participant.
yes, I have the participant.
Your claim was rejected.
No.
Then
Because again retender has been issued.
Retender.
Yes, my. I am the highest bidder, my lord.
You participate in
No,
retender.
no, I am the highest bidder, my lord. So,
QTB, that's not a ground. That doesn't give you a vested right. We will hear you.
on Friday, my lord, it may be.
You were the highest bidder. That's
Yes, my
right.
lord, the highest
In
bidder.
why has it been cancelled?
No, because my lord, some norms that it is they said, my lord, the respondent said, but as per me, there's all the clauses of the so and so notification has been, my lord, complied, my lord.
All right. But if you don't have a case, we'll impose cost.
My lord.
14.
May it please, Your Lordship.
When is it happening? Retender, when
Retender will be, my lord, held next Monday, my lord.
retender would be held next Monday.
Yes, my lord, opening of
So
tender.
therefore, it will take time. So this Friday, we will not give you. Monday, Friday, this bench may not be available. So we keep it on Monday.
Obliged, my lord.
On 17.
May it please, Your Lordship. So
Yeah.
recommendation from IA, my lord, for condonation of delay in filing read appeal, my lord. So it may be on Friday, Thursday or
Any day next week,
Next.
Monday.
May I please, Your Lordship? Also, I prayed for listing of a PIL, my lord. My lord has allowed the listing for yesterday, my lord, but it was unfortunately, it was not listed, my lord.
we had ordered.
Yes, my lord.
Before, why has it not been listed?
No,
Shall be
yeah,
listed
you can-
tomorrow?
Similar matters were listed before a coordinate bench of this honorable yesterday, my lord. So it is fixed on Friday, my lord. So may I pray that this matter may be also listed with those matters, my lord. 14th, my lord.
In that text.
Yes, yes.
That's right.
I'm obliged, my lord.
We have already ordered that. It has to be effective.
May it please your lordships. I pray for the listing of a writ appeal tomorrow, your lordships. The appeal assails the impugned judgment and order dated 1/11/2025, whereby the learned single judge upheld the order directing the closure and shifting of appellants duly licensed IMFL of retail outlet store. So the appellant's shop is the only livelihood. Therefore, this IA is filed with an interim relief
What is the
seeking
ground-
stay.
What is the ground for closure of your IMFL and why the court did not interfere?
Sorry, I'm not aware of.
So once you're aware of the facts, when you can tell us the urgency, we can have it listed on the same day or maybe tomorrow. If urgency is not explained to us, we would be loath in giving you any priority hearing.
The appellant's only source
Get
of
ready,
livelihood
see
is
the file. We may call for the file here just now and we decide. So get ready in the matter and then mention. Come tomorrow. See the file, see the order, see the issues. Tell us if it's a simple matter, we do it immediately, or otherwise we give you a time.
Daily list for admission, item 2.
May it please, Your Lord.
Mr. Shashikant had made his argument.
Yes, now today I'll.
It's your
reply to.
Your Lordship,
Yes,
You can take your seat.
Your Lordship, one submission. I have filed my rejoinder on 4th of November. I came to know that has not been placed on record. It may kindly be kept. I have got another 2 copies with me, photocopy.
Give it and bring it from the registry.
Yes.
Ask it to be
Yes, sir.
notified. Yes.
Yes.
Give a copy to Mr. Chaudhary as well.
I had already got it received on 4th of November.
Well,
sir.
Got it. May it please, Your Lord.
वहां से मंगवा लो. Yes.
My lord, there was an empanelment was done.
Hmm.
Subsequently, my lord, that order was cancelled. And following that, my lord, they were reverted to their original position. That is basically the grievance. Now, my lord, please come to page 94 of the writ petition, my lord. This enable, my lord, the writ petitioner to be empaneled as seasoned, and this was eventually, my lord, cancelled and withdrawn.
Hmm.
Now, this was on 28th of April, 2023.
Yes.
This was the guideline for empanelment of officers for holding the post of chief. You can sit, man.
CGM.
Yes. Chief General Manager. Recruitment rules of BSNL Management Service streamwise of 2023 have come into operation with effect from so and so under Schedule 1 provides that selection of officers for the post of Chief General Manager shall be made as per separate executive instructions to be issued with the approval of the competent authority. Accordingly, with the approval of the competent authority, criteria for empanelment of officers for holding the post of Chief General Manager in BSNL is prescribed as under. Now, who are eligible? All serving absorbed BSNL recruited PGM, Principal General Manager grade officer, all serving ITS grade A regular HSG, NFU level officers posted in BSNL, all serving senior general manager grade officers of BSNL for empanelment to the post of CGM of small circles like so and so, so and so, so and so, and etc. etc. So, my lord, this was the, empanel guidelines which was issued, and subsequently, my lord, which came to be, cancelled. Now, pursuant to this empanel guideline, my lord, at page 96, a notice was issued inviting application willingness.
Yes.
It was on 21st of January 2024. In accordance with the provisions of Schedule 1 of the BSNL MSRR 2023, BSNL Corporate Office has issued guideline criteria for empanelment of executive for holding the post of Chief General Manager in BSNL, wide dated so and so. In reference to the aforesaid guideline, willingness of the eligible executives is invited from all eligible officers, that is PGM level, BSNL absorbed, recruited officer, HSG,
That's right.
etc., etc.
For willingness was
Yes.
asked. Yeah.
Then my lord, will kindly come to page number 97. This is the following that my lord, many applied, and thereafter my lord, this order was issued on 1/6/2024 at page 97. Selection committee for second round of empanelment of executive officers for holding the post of CGM in BSNL has recommended the names of the following. Serial number 2012 is the petitioner. He was principal chief engineer Chennai, Tamil Nadu Circle. Now he was appointed as Milord. He was posted as chief general manager Dimapur. Now Milord, thereafter at page 98 is the posting order. Serial number 6, Shashi Khan, PCE Chennai, Chief General Manager, any Circle 2. Yes. Then, my lord, we'll kindly come to page number 857.
Page number?
857. I'm sorry. 1 second, Mil. I'm sorry.
I don't think.
I'm sorry, Mil. Yes. Thereafter, please come to page number 102. I jumped one step. Please come to 102.
Yes.
Yes. This was on 19/7/24.
Yes.
DOT White note dated 26/24 is intimated that empanelment process adopted by BSNL is not tenable for ITS cadre posts being operated in BSNL as per cabinet approval and directed BSNL to comply with its instructions with immediate effect. In pursuance to the above, officers mentioned in Annexure A who have joined as CGM on or after 26/24 are hereby relieved from the post of CGM with immediate effect and directed to join their duties as mentioned in the aforesaid annexure.
The first paragraph is very unhappily worded.
Yes.
We don't understand.
No, my lord.
Process of, the empanelment process adopted by BSNL, that's the process
What is sought to be conveyed was, my lord,
is
this
not
post,
tenable.
these posts are meant for ITS cadre posts.
Why does it reflect that?
Lord, not in so many words, but that is
Not
what
in
is.
any word. If we don't have the explanation of it,
this-
anyway, but the second part
This
makes
is
it
how, my
clear.
lord, the opposite trend started. So it says is not tenable for ITS cadre posts being operated in
In fact,
BSNL.
it conveys
Ah,
that please don't consider ITS. It conveys just the opposite.
opposite. Other than ITS, it should not be considered. That should have been the intention.
Yeah.
Correct, correct. So slightly language is not very.
But
happily
the
worded.
second paragraph, explains it.
Yes. In persons to the above, officers mentioned in Annexure A who have joined as CGM on or after 26 are hereby relieved from the post of CGM with immediate effect and directed to join their duties as
That's right.
mentioned.
This is the order which is under challenge.
Yes. Now, my lord, we'll kindly come to page number 104. Please refer to letter dated so-and-so, wide which BSNL has requested DOT to accord in principle approval for empanelment of so-and-so officers working in DOT, MTNL, other organization in the post of CGM in BSNL by calling option from willing officers to DOT for the year 2024 onward. ITS officers are being posted in BSNL against so-and-so other posts under special reserve as per cabinet approval dated 27th of July 22 and are governed by service rule of ITS cadre as per cadre post. Now this is important. BSNL MSRR 2023 is applicable to BSNL executives only, that is BSNL absorbed and BSNL recruited employees. Application of these rules by way of guidelines issued by BSNL on 24/23, making ITS officers posted in BSNL also part of empanelment on a mandatory basis for CGM is therefore not tenable. This has also led to legal challenges where it has been hard to defend the policy. So basically, my lord, what was sought to be said was that these posts are meant for ITS cadre posts and these are not meant for other cadre people. Now, my lord, what had happened thereafter at page 105, that order was issued whereby the empanelment order was withdrawn.
No, read paragraph 4.
Yes. HAG promotion to ITS officer is granted after DPC conducted by UPSC and with the approval of the ACC, and the sanctity of this process is inviolable for the cadre post. Hence, posting of the special reserve officer to CGM empanel under MSSRR 23, who are generally junior to these officers, especially with officers of special reserve pool, is not permissible. My lord, end of the day, when I place my further fact, my lord, what will emerge is the petitioner belongs to civil stream. He has his own service route. He has to climb the ladder in his own, civil stream. He cannot come to occupy a post which is meant for telecom stream. That empanelment process was wrong.
That's right. That's your case.
Yes.
That empanelment process was wrong and therefore you chose to relieve them who were
Look,
joined.
end of the day, when it comes to, my lord, reviewing an administrative decision, this is always there, my lord. Otherwise, a person who is not, no, my lord, there is a common cadre concept. I'll
Mr.
explain.
Chaudhary, that's a very convenient way of defending no. Question is this.
Yeah.
Now, from different streams, it converges to a mainstream of CGM. Now, there is no difficulty.
No, no,
He's
no. No,
BSNL
no, 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 no.
MSRR 2020.
No. In his stream also he can become CGM. That is not the case here. He can become CGM in his own stream. I'll place that. Let me place the facts, my lord, then I'll articulate my arguments. Yes. Then, my lord, will kindly come to 105. This is 22/7/24. A review of guideline for empanelment of officers for holding the post of Chief General Manager. Now, I'll read from para 3, my lord. In view of the aforesaid direction of DOT, Management Committee of BSNL Board has reviewed the above cited empanelment guideline dated 24/23 and have now approved the following. Existing guideline for empanelment of officers for holding the post of Chief General Manager in BSNL issued by BSNL letter dated 24/23 and 26/5/23 stands withdrawn with immediate effect. Existing panel of officers empaneled for holding the post of CGM in BSNL stands lapsed with immediate effect. Officers from regular ITS higher administrative grade and HSG non-functional level ITS officers will be identified and shall be posted as CGM in BSNL strictly as per direction issued by DOT while note dated 28th of June of 2024. So, my lord, this empanelment process was done away with because it was not consistent with the extant rules. Therefore, this was recalled. The effect of recalling was, my lord, there was then, my lord,
No, what does it mean? The case of absorbed directly recruited officers of BSNL for holding the post of CGM shall be taken up separately in due course.
yes,
Now, where is that policy?
that 26/24. No, look, the rules are there. It's not a question of policy. Let me place the facts, my lord. Then, my lord,
Anani, then we must read because this is the most important communication.
yes, yes.
Now, four says the tenure as CGM of the officers appointed to
Tenure
empanel
of CGM of tenure as
end.
CGM officers appointed through empanelment process will end as soon as the new officers are posted as per the direction of DOT dated so and so. Yes,
This therefore, one of the submissions of Mr. Shashikant was that true you have withdrawn it. But then you have made it contingent on fresh empanelment for ITS HAG and or ITS HAG NF.
absolutely, yes.
So the fact in his case was that he was asked, he was relieved, and somebody from other place, neighboring circle, was made in charge.
No, he relinquished his charge, he has suppressed that fact. He relinquished his charge.
No, why will he suppress that?
No, yes, suppressed, he has nowhere brought in.
Just-
It is only in our affidavit we have brought out that.
That's right, Mr. Chaudhary.
Yes,
If he says, if the department says that you are relieved,
yes.
now what option he had? That's not an
No,
issue.
my lord, what I am saying is.
He has
when
relinquished his charge.
When he approached the honorable CAT, he should have said, my lord, even if he relinquishes, he is not debarred from challenging an order, but he should have come up with that
But
statement.
we will not see it as suppression. We are not testing it on a different angle.
No, what I am saying is, my lord, all that I am trying to say is, he relinquished the charge.
He did.
Ah.
He did. Agree. So any option an employer has,
Anyway, that is not my lord.
that's not your answer.
That is not our expectation, my lord.
That is not the argument on which the decision will hinge.
Certain.
We are not going to tell him
I'm
that
just-
you suppressed.
By way of a narration of facts, I am just pointing it out.
He questions it.
Yeah.
He questions that, all right, you have withdrawn the policy, you're the employer, you have to decide.
Even if
then-
he,
but
even if
then
he
that-
relinquishes, my lord,
But that
he is
withdrawal,
not debarred from challenging.
he's
Let
not
us be very clear about it.
That's true. When this is being done for people who participate in interview process and then come back and say that this rule was faulty, Supreme Court says that no,
My
he
lord,
could not have known.
My endeavor would be to satisfy your lordships that this 20th of April 2023 empanel guideline was not correct. When authority realized
They
that some
made
error
that-
has crept in this decision-making
Very-
process,
That's a-
authorities recalled it.
That's a broad argument. Nobody can question that.
Yes,
I mean, nobody can question the correctness of, not the correctness. We will be testing the correctness of that decision, one.
Yes.
Number two, we are on a different issue altogether. Don't think that we are questioning you on this.
no, absolutely not.
The tenure will end. Those who have, see, there are cases where there has not been an empanelment. If empanelment has been executed and he has been posted, then some kind of a right accrues to him. Correct? So this can be taken away only by established procedure. Procedure you say in your letter dated 22/7/2024, if I remember correctly, this was one of his major arguments to support the additional arguments that the tenure he was having his tenure, you end that tenure. And there is a direction that you will end it as soon as new officers are appointed. Now, where was that process undertaken? Now, you have not undertaken any process. You are from the same list of successful impaneled persons. Somebody was posted in some other Guwahati circle. He was asked to take over the charge.
No, my lord, nearby. Guwahati, yes, yes, yes. Assam circle.
That's right. So it says that the empanelment process will end only. Question is this. Now, why he is saying so? His argument was, you have to meet that argument, that he is to retire in December. The process has not started. Therefore, he would have been more honorably asked to exit if appointment would have been made. He would have gone. True it is that he relinquished his charge and now he is questioning it. But this is one of the grounds.
No, my lord, if he would not have relinquished the charge, in
Other
that
would not
case,
have-
my lord, that argument would have hold good. Having relinquished the charge, what else do, my lord? We have to appoint somebody. He relinquished the charge. That is what page 857. That's why I wanted to place that. Please have this page 857, my lord. He relinquished his charge.
Very
He complied with the order dated 19/7. Charge report and receipt for cash and stamp
This
on
is
charge,
857.
transfer of charge.
857 is the format.
Page 857, my lord.
That's the format.
Yes,
That's the format.
yes,
He just signed it.
yes.
No, where is it?
No, my lord, he has voluntarily done it. It's not that somebody was relinquished by Shashikant.
This is not. Okay.
On 27 afternoon,
Right.
in accordance with BSNL order dated so and so. So he relinquished it. Therefore, perhaps, my lord, that argument will not hold good. Now let me finish my facts, my lord, then I will come to the.
But you have treated him very shabbily.
Yeah.
You have treated him very shabbily.
Anyway, my lord.
That's not the way an employee is treated. And he is to retire. That's one aspect of the matter which should have been taken into account. Who questions your powers? Nobody is questioning your
End
powers.
of
You're
the
the
day,
employer.
he was not the only officer who were promoted like him, or sorry, posted like him.
He's before us, no?
Anyway,
He's before us.
yes. Anyway, my lord, let me narrate my facts.
All right.
Now, please come to the rule position. Why we say that empanel process was wrong?
Yes.
Now that I will establish. Now, please come to page number 797.
And all this empanelment process was going on under your nose.
Yes,
And you realized it only after you executed everything.
yes, yes. Please come to 797, my lord. This is the telecom rule. The rule starts
One
at
second.
page 798. My lord will kindly come to page 800, rule 6. Now it will be clear from this rule, my lord.
These are the rules.
Yes, yes.
7, 9, 7.
Please come to page 800, rule 6. Six point one and 6.2.
Page 800.
800. All the executives regularly appointed to various grades before commencement of these rules.
These rules commenced from when?
Yes, my lord, the rule came into
Published by
force on
BSNL
31st of December
December
2022.
Okay.
It starts at page 797, my lord.
Hmm.
Please come to page 800.
Hmm.
All executives regularly appointed to various grades before commencement of these rules, whether recruited by the government and absorbed in BSNL or appointed on regular basis via BSNL, shall be deemed to have been appointed to their respective grades in BSNL. 6.2. Group A officers absorbed from Indian Telecommunications Service, Group A, will form part of the telecom operation stream of BSNL MS, and all these absorbed Group A officers shall rank en bloc senior in their respective grade to any executive, etc., etc. So, my lord, all executives regularly appointed to various grades before commencement of this rule, and all Group A officers absorbed from Indian Telecommunication Service, they will form the, the service. Then my lord will kindly come to page number 804. Under this rule, who can become CGM Telecom? Please come to me, Lord. Serial number 7 towards the bottom of the page. Principal General Manager / Chief General Manager, so and so is the number of post 63, 37 CGM, 26 PGM. Now, on the right hand, extreme right hand side column is the Miller qualifying service. Executives in senior general manager's grade with 3 years of regular service in the grade of GM as on 1st January of the vacancy year. Now, this note is important. Selection of officers for the post of CGM shall be made as per separate executive instructions to be issued with the approval of the competent authority.
That's right.
Yes.
So this has to be read with page 97. Now let us come to 97 again.
Yes, my lord.
Not 97, not 97.
97 is the order.
No, 97. Come to page 94.
Yes, my lord.
Now it says, read the first part.
Yes, all serving absorbed BSNL recruited PGM grade officers.
No. The recruitment rules, read from the top.
Page number, my lord.
94, annexure 3.
Huh.
See,
They recruit.
why, Mr. Chaudhary, let's just try and understand why we are saying so.
Yes,
You have read out and flagged the note.
yes,
Note at page 804,
yes,
correct?
yes,
Now, the note is referred to here.
Yes.
In 94.
Yes.
Now, read.
yes. Precisely, my lord. That as per separate executive instructions to be issued with the approval of the competent authority.
Accordingly,
Yes,
with the approval of the competent authority. That means this note has not been forgotten.
yes,
With the approval of the competent authority, criteria for empanelment of officers for holding the post of CGM in BSNL is prescribed as hereunder.
yes,
And then you bring all these people.
yes.
You should have said no.
No,
So this has
subsequently turned out that these civil people and other, they cannot hold this post because it is a technical post. Let me place the rules, my lord.
Okay.
Then my lord will kindly come to page 805. Now this very clear, my lord.
No, it
Who
is-
can become CGM is specified. Please see, my lord.
Oh,
Page 805.
Hmm.
Please come to last 4 sentence of 6.
Hmm.
Last 4 sentence.
Hmm.
CGM, PGM level posts shall be filled up from regular ITS, HAG, NF level ITS officers deployed in BSNL who have entered in the 27th year of service as on 1st January of the year, calculated from the year following the year of examination on the basis of which such officers have been recruited in duty. So who can become CGM, PGM? ITS, HAG and HAG NF level ITS officer. Not my lord a civil wing officer. For them there is a separate rule. I'll place that. This is the situation, my lord. Now my lord will kindly come to their rules. Which, no, before that, my lord, my learned friend was trying to refer to, please come to page 798 for a moment, my lord. Now, it also envisages a concept called common management post. Perhaps he was trying to take advantage of this. Let me place this also. 2.3 at page 798. Common management post of GM level and above of BSNL management service like HR, administration.
Where are you reading?
marketing.
Page seven
Page
ninety-eight,
number 798, my lord,
2.3.
2.3.
Hmm.
The common management post of general manager level and above of BSNL management services like HR, administration, marketing, sales, EV, etc., where technical expertise is not necessitated by virtue of telecom operation requirement may be manned by an executive at GM level and above with requisite qualification from any stream of management service on merit basis. Scope of the common management post can be expanded as per the business requirement of the company with the approval of the management committee of the BSNL. So, my lord, only where
He is an electrical engineer.
civil engineer,
He is a civil engineer.
civil engineer. So, my lord, where a technical expertise is not necessitated. So, my lord, to run that chief general manager's post, it's a post on the technical side. My lord. A civil engineer, he cannot man that post. Now let us come to their rules, my lord. Where he can also vie for the post
There,
of,
there means who?
yes,
There means who?
civil,
Okay.
849, my lord. Now their rule starts at page number 844, my lord. Now this is called BSNL Management Services Civil Stream Recruitment Rule. So his service is governed by this set of rules. Now please come to page 8456, initial constitution. Towards the bottom of the page at page 45. All executives regularly appointed to various grades of civil stream of BSNL management service before commencement of this rule, whether recruited by the government and absorbed in BSNL or appointed on regular basis by BSNL shall be deemed to have been appointed in their respective grades in BSNL. The Group A officers absorbed from Indian Post and Telegraph Building Work Service, Group A will form part of the civil stream of BSNLMS, and all these absorbed Group A officers shall rank N block senior in their
So in
respective
this
grade.
civil side,
Yes,
also Indian Post and Telegraph Building Work Service.
yes,
So it is also, so he doesn't come in that. He doesn't come in. This is again ITS. This is again ITS with a separate,
separate stream.
like Department of Income Tax and Customs, interchangeable these days.
No, no, my lord, now this page 849 will clarify everything. Who can become chief general manager in the civil stream? And you see page 849. Please come to me, lord, serial number 7. Chief general manager, principal general manager, principal chief engineer, number of posts 1 CGM, 4 PGM. So here also there are, my lord, chief general manager. Executives in senior general manager grade with 3 years of regular service as on 1st January of the vacancy year. So petitioner is a, my lord, principal chief engineer. Now, my lord, he cannot become CGM telecom, but he can certainly become CGM civil stream. Now, there was an error committed by the authority. The error was, you have brought in people other than telecom people. Now, the government says it can't be done. Now, the question is whether government is possessed of the power or not.
Who will question this?
Yes.
Who will question this?
Yes. Now, my lord, now please come to the cabinet note at page 847. No, cabinet decision.
847 is
I'm
not.
sorry, my lord, not cabinet note 3822. I'm sorry, my lord. At 842, my lord. I'm sorry. 3822.
Hmm?
Page 842, Mr. Kindly see the subject. Cabinet approval for operation of ITS post in BSNL MTN regarding
842.
page 842. Mr. This refers to Office Memorandum of Event Number dated 29th of December 2016, read with corrigendum of event number dated so-and-so. As conveyed by DOT OM dated 2nd of August 22, Union Cabinet in its meeting held on 27th of July 22 has considered and approved the proposal for amendment in the special reserve for posting of ITS Group A officers in BSNL in Cabinet Decision of 2016. Accordingly, para 2.3 and 3 of OM of event number dated 26th of December 2016, read with corrigendum stands replaced as below. A special reserve of 564 for posting of ITS officers to BSNL. The special reserve will be non-diminishing for 5 years and it will be diminished in a phased manner thereafter as the PSU develop their own cadre. Number of ITS posts to be operated in BSNL under the special reserve will be as follows. Higher administrative grade, it will be 34. Senior administrative grade, it will be 353. And junior administrative grade, it will be 170. Now, my lord, if your lordship, now eventually I'll submit, my lord, this empanelment guideline, it was violative of clause 6, read with clause 7 of schedule 1 of note 6 at page 797.
797.
Sorry, 797 it starts. Now, this is violative of page 804, Miller. Precisely, to be precise, page 805. Last 4 line. CGM, PGM level post shall be filled up from regular ITS HAG, and NF level officers deployed in BSNL who have entered 27th year of service as on 1st January of the year calculated from the year following the year of examination. So these people who belongs to ITS, HAG and NF alone are eligible to hold the post of CGM or PGM. Now he is a person, he is a principal chief engineer from the civil state. He has got his own service rule and he has got his own career progression, approach that he can also become CGM minister, but he cannot. Now, in the name of common management cadre, unless there is a technical expertise, that can't be envisaged. So, what the authority did, my lord, having noticed that an error has crept in the empanelment guideline of 20th of April 23,
But then
it was corrected.
No, but it is very wrong of this officer, whoever has done it, whose signature is it? Deputy General Manager Personnel, DPSSM. He says that as per executive instructions to be issued with the approval of the competent authority, which is the for empanelment.
No, it was done. But even then, my lord, actually, my lord, in R.R. Verma's case, similar question arose. I'll place the judgment, my lord. Please have this. 1983 SCC 402. My lord, there could be error. It can always be corrected. That is what Supreme Court says, my lord. 1983 SCC 402.
1983.
My lord will kindly come to the facts, page 403. First para. The judgment in this appeal at page 403 is really an appendix to the judgment pronounced by us in civil appeal number so and so. The relevant facts may be gathered from that judgment. The further events requiring to be mentioned are these. While the writ petition filed by Ahluwalia in High Court of Himachal was pending, some of the respondents to the writ petition and one R.R. Verma, all direct recruits, used to file a writ petition in Delhi High Court, questioning the notice dated June 29, 1973, calling upon them to submit representation against the year of allotment proposed to be allotted to Shawnee and Daliwal and Ahluwalia. After the writ petition of Ahluwalia was allowed, and after central government passed the order dated July 27, 1979, pursuant to the direction issued by the High Court of Himachal Pradesh, the Delhi High Court dismissed the writ petition filed by the direct recruit as infractor. The High Court, however, granted a certificate of fitness to appeal to this court under Article 133 of the Constitution. Therefore, this appeal, the writ petition having been dismissed as infructuous, we do not see how a certificate under 133 could have been granted, but we do not want to dismiss the appeal on that preliminary ground. R.K. Garg, Learned Counsel for the appellant, challenged the order of central government dated on 3 grounds. Rule 3 of the All India Services Condition of Service Residuary Matter Rule offended Article 14 of the Constitution and was ultra-vires as it conferred arbitrary and uncanonized power upon the central government to grant relaxation wherever it pleased to do so. 2, the discretion to relax the rule was wrongly exercised in the present case. Central government was powerless to review its earlier order.
To come to para 5.
Yes, para 5. I'm on para 5. I place the fact. Now, please come to me, Lord. The sentence started. All cases cited by Sri Garg are cases where government was exercising quasi-judicial power vested in them by the statute. We do not think that principle that power to review must be conferred by statute, either specifically or by necessary implication, is applicable to decisions purely in an administrative nature. To extend this principle to pure administrative decision would indeed lead to an untoward and startling result. Surely any government must be free to alter its policy or its decision in administrative matters. If they are to carry on their daily administration, they cannot be hidebound by the rules and restrictions of judicial procedure, though of course they are bound to obey all the statutory
So
requirements.
therefore, the import of this judgment is that even if that decision at 94 is reviewed later, finding it to be wrong interpretation and wrong consideration of people not belonging to the requisite cadre, so that even notice was not required to be given to them because it was a purely administrative order. So this is kind of review of an administrative order, which cannot be reviewed by the courts.
No, my lord, there might.
That's what these judgments say.
Correct,
No,
correct. I'm not saying. No, my lord, what end
no,
of the
that's
day.
that's in your favor, Mr. Chaudhary.
Yes.
But I have only, made it simple. And what it says,
Explicit. Lordship
all
has
the-
made it
all the
explicit.
cases cited are cases where the government was exercising quasi-judicial power.
Quasi-judicial power.
Here it is no
Not
quasi-judicial
quasi-judicial.
power vested in them by statute. We do not think that the principle that the power to review must be conferred by statute either specifically or by necessary implication is applicable to decisions purely of an administrative
Yes.
nature. The follow-up to this is that if a person gets affected adversely also,
Then also,
he need not be noticed.
yes, it can be, my lord, it can be reversed. At the end of the day, there will be chaos in the administration. In other words, my lord, some undeserving person will be holding a
It
post.
is not a question of undeserving. It's a question of a different stream. We can't call Mr. Sashikant to be undeserving.
No, no, undeserving in the sense he doesn't belong to
Don't
telecom
qualify.
stream.
They don't
Telecom
qualify.
stream. So therefore, my lord, eventually my submission is, my lord, that error was corrected. In that process, can it be said any fundamental right or any legal right of the petitioner has been infringed? If end of the day, my lord, when you are seeking that you should hold a particular post, then where is that enforceable right of yours? Which statute says you are eligible to hold that post? If you have, please show. End of the day, my lord, we come to the court of law to enforce our rights, not to create a right. The right must exist, and we come to enforce that right. What is the right of the petitioner, Sri Shashikantji, to, my lord, hold this post of Chief General Manager? So therefore, my lord, my humble submission is, my lord, there is nothing wrong in the decision-making process. There was an error which resulted in that empanelment process, and we have corrected. Whether we can do it or not, that eventually it boils down to that. Going by judgment in R.R. Verma, that when it comes to purely administrative decision, this is permissible, even at the cost of natural justice. That is my humble submission. I don't think I'll have to add anything more to my submission. And that way, my lord,
You'll have to
tribunal
do
has
one more-
rightly,
You will have to do one more.
yes, sir.
Now, make a note, sir.
Yes,
Page 94, 96. Just make a note, 94, 96, 97, 98, 102,
yes,
104,
Yes.
105,
yes,
857,
yes,
797,
yes,
800,
yes,
804.
yes. I'll make a compilation.
And then just a minute, 805, 798,
Yes,
849,
yes,
842,
yes,
and 797.
Yes.
In this sequence,
yes,
you just have a pull-out compiler.
yes, yes, I'll do that.
Do it today.
Today,
Ask
today,
your junior.
today.
Yes. Yes, Mr. Shashi.
Lordship,
The page number in that sequence. Don't change this.
I know, I'll do that.
And give us the photocopy of R.R. Verma.
Yes,
2 copies.
surely, my lord.
may I start your lordship?
Yes, yes. But Mr. Sashikant, no repetition. You speak only, you answer him.
Your lordship, I have submitted my rejoinder. Some points are there from my rejoinder. I will just
Please.
explain.
The rejoinder.
Your lordship, the very premise of the respondent is based on their old heritage they have inherited from DOT. This all depends upon the old story, like once upon a time there used to be a DOT. And these rules prevailed in DOT. ITS officers were holding the post of CGM, so now they cannot hold other officers. They cannot hold the post of CGM. They themselves are confusing what they want. They do not, they are confusing interchangeably using the words telecom stream officers and ITS officers. Para 6 of BSNL MSRR talks about ITS officers. But in para 39 of their submission to the OA, and while replying this writ petition in the counter affidavit, they themselves have agreed and committed and written that these CGM post is open not only for ITS officers, for other telecom stream officers of BSNL who are absorbed and who are directly recruited. So straightway, whatever they are telling, it's totally, I mean, it has got no relevance now. Just for the sake of argument, they are making some argument before this Honorable High Court. Now, Your Lordship, I'll one by one, in my rejoinder, I have written some 16 points. You are there, Your Lordship may kindly go through it. But I will start with this. Kindly come to page 925, Your Lordship, of my rejoinder.
Yes.
This is the hierarchy tree of Tamil Nadu Circle, Your Lordship. In the top square block is the CGM. He is heading the circle, and below him there are more than 20 general manager and principal general manager level officers reporting to him. Now, Your Lordship may kindly come to row 3. First person who is reporting, he is chief engineer electrical. Third row, second person is senior GM finance. Fourth row, I am reporting. My photo is also there here. Then PC is civil structure. Then in the 5th point, general manager HR and admin. Your Lordship, general manager sales and marketing, general manager enterprise business, all these verticals are reporting to chief general manager. This clearly shows that the post of chief general manager is a multidisciplinary task, which he has to supervise the work of not only telecom stream,
That's right.
he has to see
But
also.
the question is that the rule says that these ITS persons will en bloc be senior to you who have been absorbed or appointed by BSNL. They say so.
ITS officer, Your Lordship, who have absorbed in BSNL. Not the ITS officers who are working on reputation.
The rules are that ITS officers will be, if they get absorbed, naturally, ITS officers are there not in BSN. ITS officers absorbed in BSNL would be en bloc senior to all officers either appointed by the government or appropriated by or absorbed by the BSNL,
Okay,
which is your case.
your lordship.
So that's the rule. En bloc, they will be.
Seniority is immaterial,
The
lordship.
question,
Yes.
your maximum ground would be that subject to the competent authority note, the notification was issued, meaning thereby that it was approved by the cabinet or the competent authority that this time the empanelment would be from amongst ITS and you as well.
Yes, your lordship.
One. The second argument of yours, if I remember from that day, so you were so lucid in your argument that we did not make note of your arguments, but we remember that next you said that a special cadre of ITS officers of 560 heads,
Your lordship.
I mean, distributed amongst three categories, would be non-diminishing
Your lordship.
till 21 to 26.
26.
Thereafter, the department the BSNL shall arrange, shall work for its own officers to be posted at the top.
Your lordship.
So we are still in that non-diminishing cadre. So 34 of the CGMs,
34 will continue, your lordship.
34 will continue
Continue. Not in the CGM, your lordship.
on the post of
HAG.
CGM.
Not in the CGM, your lordship. HAG, including PGM, CGM both. There are 63 posts of PGM, CGM grade. So this, out of this,
PGM, CGM, there is no difficulty. For the post of CGM, 34.
no, your lordship. Nowhere it is written.
The rule is there, Mr.
Your lordship, DOTO never says that it is for CGM.
No,
It
no,
is HAG.
come to that paragraph.
Yes,
Come to that rule.
your lordship.
Your argument is good. Wherever it is good, we lay stress on it.
Your
Number two,
lordship.
why did you relinquish if you were going to the CAT?
Your
You will
lordship,
question that.
Your lordship.
Just a minute. Now we are placing your case at the highest. Now, rightly or wrongly, the empanelment process adopted by BSNL was ultimately found to be wrong. Wrong or right, we are not to question. That is pursuant to the reading of the rules and what was understood by the employer. So his argument, his master argument is that what is that called? His point is that the powers the government has. Your ground is that power has you. This is not under stealth. This is under their supervision. There was a clearance for this kind of empanelment. I passed the rigorous test at 2 levels, and then I competed with ITS officers, and I was given a posting.
Okay.
If I were given a posting, I could not be asked to, get out of that posting and go back to principal as a CGM or not CGM, principal chief engineer, principal general manager, electrical in Tamil Nadu. The second important point of yours would have been that, well, even with the rectification of the empanelment process, an earlier process adopted was not found to be correct. Once you were given that posting, that would have lapsed. Agreed, the panel lapses, but you are taken away from the panel. Therefore, your service should have continued till a fresh panel was made of ITS.
Lordship, can I submit first?
Then
And
just
then,
a minute,
Your Lordship.
let us understand it this way. Now, that perhaps was your very strong point, but you relinquished without questioning.
Your lordship, I was holding the post of chief general manager, which is the highest post. Did the respondents want that their administrative anarchy should prevail in that circle? If I don't relinquish,
No.
they would have.
That's a different question. I mean, we are not questioning your wisdom. Are we? You had no choice.
You had no choice.
You had no choice. That
Yes,
we said
yes,
it so many words.
Yes,
We are not questioning
Lordship.
that.
your lordship.
Who would say? Suppose I tell my court master, please go. We will have another person arranged. What option he has? He goes. He goes and joins registry.
Your
That
lord,
oral order is good enough. No written order is required.
your lord.
But you got a written order. Of course, the comparison is not apt, but I'm only telling you the person at the high position. So you relinquished. Correct. In your wisdom, you were a disciplined officer.
Yes,
You've gone back. Now, they saved in their own the way how to implement this, because panel was prepared, postings were made, but they said that no, this panel was wrongly prepared, it lapses, with nothing doing. We change it. All these people who have been promoted, who do not belong to the ITS, they'll go back to their parent cadre, and the post would be filled up by HTS. Till that time, they shall remain there.
That decision itself is wrong, Your Lordship. I had explained that. I will explain now
That
also.
decision making fact, Mr. Sashikant, we have our own limitations of testing a decision. If you ask us to question the wisdom of the rule making authority, we do it only if it is absolutely perverse, exclusionary.
I will explain, Your Lordship. Let me go through this, whatever I have submitted in my rejoinder. So this is a multidisciplinary post, sir, Your Lordship, this CGM post. To him, 20 number of general manager level officers are reporting. Whereas I have enclosed my this thing chart, hierarchy chart.
No, you were right. I was wrong. At page 107, no, you're right. I read it as CGM. This ITS, the 34 post would be higher administrative grade. Senior administrative grade would be 353 and junior. I thought CGM post is 30. No, you're right. HAG, till that time it's on.
HAG only, Your Lordship. DOTOM says only HAG.
All right. So HAG.
HAG.
Now I build up my argument, the third argument from here. I thought it was only CGM, then you had no case. Now this is HAG, but here from the HAG. So ITS HAG, they say that this CGM's post will be filled up only by them. The rule said.
No, rules.
They say means rule said.
Your Lordship, I will explain. Let me give me some time, Your
I have
Lordship.
given you
Otherwise-
portals.
No, that I had already explained, but I have written in my rejoinder. I'll come by one. Please give me some time, Your Lordship.
Okay, uninterrupted time, 15 minutes you have.
Your Lordship, please let me.
There are
so
other
this-
cases also.
this-
No, the entire courtroom is full.
Your Lordship, please. This is my reporting structure as page 928. Only 2 DGM level officers are reporting, so we cannot say that the PC, civil, and CGM are equivalent post, and it can.
How many persons, not from ITS cadre, were made CGM?
3 in my panel. 3.
3.
3.
And how about 2 others? They have gone. That is not the question on which we'll put you on a back wicket. No. But I'm just asking for information.
No, out of 4, 2 were ITS.
You
2 were
said
non.
3.
No,
You
3 from the entire panel. Entire panel, out of 14 people who were selected for the post, CGM post, 3 were from non-telecom background,
like you,
like me.
including you. Including you.
Including
3.
me, Your Lordship.
So what about 2 others who are posted?
One person also relinquished, and he decided not to contest.
Not to contest. The other?
And another person I'll talk, Your Lordship. I'll talk about the this first in panel batch. Kindly come to page 927.
Yes.
927 is the hierarchy structure of the Assam Circle CGM. Mr. Rupa Paul Chaudhary. She is an impaneled CGM of 2023 batch, Your Lordship, from finance background, not even from engineering background. She was allowed to continue on the post up to March 2025, even after 9 months from the date I was reverted. That itself shows that telecom officers are competent to hold the post.
No, competence is, who is questioning?
No, Your Lordship, if there was any barrier, any functional or administrative or policy barrier which stopped non-telecom stream officers from holding the post, they would have immediately reverted Mrs. Rupa Pal Chaudhary. But it was not done. That clearly shows that this was not an issue. Even in the DOT ID note, DOT OM.
This empanelment, she comes of which empanelment? Which
First empanelment, 2023. She had already worked for 1 year. Another 9 months. 1 year, 9 months she continued on the post.
was not issued any instruction to release.
No instruction. No instruction. So, I'll explain, Your Lordship. But please give me some time. I'll explain each and every point. I'm fully prepared with whatever their counters are there. I'll explain.
Yes.
So this non-telecom stream, Madam Rupa Pal Chaudhary was, in my case, even in spite of the interim stay order of the learned tribunal, I was not allowed to continue on the post. Even after dismissal of the stay vacation petition I was not that willfully they disobeyed the interim order,
There was
order
an
of the
en-
tribunal.
There was an interim order of CAT holding that you should be allowed to remain on that.
Remain on that.
What did they do?
There was a direction also to the respondent, Your Honor. Not only that, it was state the operation of
That's
interim.
right. So the BSNL came to High Court.
BSNL came to High
What
Court.
happened in that?
They got it vacated, the stay from this High Court, Honorable
And
High
then
Court.
you went to Supreme Court.
Then I went to
Supreme Court said that no, we will not interfere. Let the CAT decide.
Let the CAT decide, and there was also an observation by the Supreme
Therefore,
Court that
this-
without getting influenced by the observation made by the Honorable High Court.
Correct. So therefore, the issue that during the period when the interim order of the tribunal existed
Your Lordship.
and that order was violated, that issue stands completely, out of question. It
Your
goes to
Lordship,
the back
okay.
burner.
I agree. I am just telling that how they are willfully, selectively disobeying or obeying. Now also the Learned Tribunal has given direction to pay my salary. They themselves transferred me to Guwahati, NE2 circle as a CGM. That transfer, TA, DA, everything has been stopped. They have not paid anything. That means it's a complete harassment, Your Lordship.
Chaudhary, why is it they're here? They're
This-
not being paid?
This is harassment, Your
He
Lordship.
came from Chennai to Guwahati.
That my lord, I will look into it. That if there is a grievance, definitely, my lord.
He is not to be faulted.
No, that will look it. No, that will see.
Your Lordship, this is a complete misuse of authority of official position. It is in spite of Learned Tribunal direction and dismissal of their review application also. I would like to read it out from what is the judgment. They themselves have written the Learned Tribunal that this entire chaos was created by BSNL only and why he should be punished.
It has been.
It has been. So
We endorse.
you see, this such a strong decision, still they are not implementing. That means they want to harass. They are thinking that by approaching to judicial forum, I'll create trouble. They know very well that they are on wrong footing. I'll just explain. They'll give me some time, Your Lordship. Each and every point what they have been doing, I will explain here. They have given wrong affidavit twice before the Learned Tribunal to get this favorable judgment. I'll just explain. I have written everything with letter, number, and date.
Yes.
Kindly come to Your Lordship. This now they are telling another point that CGMBW they have got their own channel of promotion in the same vertical, civil vertical.
Yes.
I am reporting to CGM. I am being the head of the civil team, Your Lordship. I am reporting to CGM Tamil Nadu Circle. I am not reporting to CGM Civil in corporate office. That itself shows that up to CGM level, this all vertical gets merged. The hierarchy T. Kindly go through hierarchy T at page number 928, Your Lordship.
Yes.
Page 928 is the hierarchy T of CGM Civil. Only 5 GMs are reporting to him from civil team. No chief engineer from field is reporting to CGM Civil. Now kindly come to Your Lordship, this page 926. Page 926 is the hierarchy tree of Maharashtra Circle. CGM is Mr. Harinder Kumar. He is empaneled CGM of 2023 batch. Now presently also he is holding the post of CGM. To him, in the first row, Your Lordship, third column,
Your empanelment is of which year?
2024.
24. And all these 23 people remain.
I'll explain, Your Lordship. Kindly give me some time. This first row, third column, he is Mr. PGM Pune Telecom District, Mr. Samuel Batambre. He is quite junior to Mr. Harinder Kumar in the seniority list. But still being senior to CGM, Mr. Harinder Kumar, he is reporting to Mr. Harinder Kumar. Now they issued DOT ID note with a strict instruction that seniority of ITS officer is inviolable. It cannot be violated. But willfully they themselves are violating this rule. Selectively they are applying this DOT ID note. For the in case of reversion of all the officers, they reverted in mass, citing a ground that the seniority of ITS officer is inviolable and it is not tenable. Whereas here they themselves have maintaining this seniority, violating the seniority rule. Now, another person, your lordship, I have got all proofs also. Kindly come to page number 947. This is the seniority list of ITS officers. This is a seniority list, your lordship. Now, kindly come to page number 952, your lordship.
Yeah.
Your lordship, this Harinder Kumar is at serial number 134. And Mr. Samuel Batambre is at 123. That means Mr. Samuel Batambre is quite senior to Mr. Harinder Kumar, but still he is reporting. Another person, your lordship, Mr.
I mean,
Harshvardhan Singh.
For some time, I realized that since I am asking questions from you, you are getting lesser.
No,
time.
no, no, sir,
But
never.
the difficulty is that you are going tangent. I have to check you.
Your
Now, this seniority and block is vis-a-vis the ITS officers and absorbed officers of BSNL. Correct. So, in between ITS officer, he also participates for empanelment, a senior one and a junior one also participates in empanelment. Here it is merit comes seniority. So merit has been given due weightage in empanelment, he gets above. So he is the CGM. Listen to this. Now, there is amongst the chief justices and judges, Supreme Court judges appointed. There could be a situation where a judge who is not the chief justice, who has worked under a chief justice, he becomes a Supreme Court judge. Can you question it? This seniority is not being disturbed. But this, what you're talking of 124 and 137, that's a different issue altogether. Anyway, you proceed.
Your lordship, can I see this in mass block, that seniority, I'll go back to that, your lordship. Kindly. So this Mr. Harshvardhan Singh, he's at serial number 124. He was also reporting to Mr. Harinder Kumar, being senior to him. He protested that no, I cannot work under him because I'm senior to him. So he was shifted to MPNL. That means the seniority could have been maintained by this way also, by rearranging these posting of officers from one place to other place, and by taking the willingness of the officer that, okay, I'm willing to work.
That argument, unfortunately, we must tell you straight away, that argument is not appealing to us. That argument is not appealing to us. Your arguments were absolutely strong when you said that. We understand that. This seniority question, I mean, that's nowhere. And if suppose at number 124, Harshvardhan Singh would have complained, not you. And you're not complaining, you're trying to draw a parallel. That is something different.
Your lordship, this DOT ID note clearly says that seniority is inviolable. There is nowhere that selection process.
How is it going to help your case, mister? I have followed. It is inviolable, badly drafted. Inter-C seniority inviolable, they are not talking. They are talking about seniority vis-a-vis the officers. From chief engineers, from finance people, from other branches, from civil stream. If you conflate these two issues.
Your lordship, nowhere it is written in the DOT ID note that
this is what will be
your lordship.
It's very clear. Despite bad drafting, it is very clear that, you know, the ITS HAG or HAG-NF, non-functional, when they are absorbed, their seniority would be senior if they have done 27 years of service. They would be placed above all of you.
Your lordship,
Your lordship,
in the case of CGM empanelment, there was no issue of seniority. All eligible officers were.
That is the question. No, that was found to be wrongly interpreted. And see, this is with respect to empanelment of 24. You must know your case. Now, I could have heard you uninterrupted and I could have gone back and written the judgment. But since you're making such efforts with your daughter, you must know where you stand. You must know, you must be communicated where you stand.
Your Lordship, kindly, can I take some time to go through this, whatever the clause?
We will go through this. You just summarize your points. You have been badly treated. Do we deny that? You have been.
Your Lordship, they have given this thing that all the impaneled CGMs have been reverted. But again, the same day, 28, one order was issued by which 3 CGMs of impanelment were reverted from the post of CGM. And the same day, 28-1, they were reposted on the post of CGM. Is it the way the government should work? If something is not fishy, why they should do it like this to bluff the tribunal that all have been reverted? And again, the same day, all these 3 people were posted. I'll just see kindly, Your Lordship.
They were posted at CGM.
Posted at CGM?
Then what happens? But you say that all 3 went back.
No, that'll, Your Lordship, kindly see the page, Annexure 34. Page number, Your Lordship, 730 of my
Yes.
writ petition. 730 of my writ petition.
So we have followed your grounds. So what do you want to say now? 7:30. We will see. We will examine everything.
Lordship, I'll explain all these things so that it will be easier for Your Lordship to understand what I want to say and on what ground I have. 730 is the order by which Mr. Seshachalam, Mr. Ajay Kumar Karhara, Mr. Harendra Kumar, these 3 CGMs were reverted from the post of CGM. They were posted as a PGM. 730, Your Lordship.
Yes, then?
Then on 731, page 731, the same day, 28/1/2025, these 3 officers are appearing at 4, 5, and 6. They were posted again as a CGM Andhra Pradesh Circle, CGM Punjab Circle, CGM Maharashtra Circle, at the same place earlier where they were working.
And what is their position now?
They are working, still working.
As CGM.
CGM. So they have
And they
given,
are not ITS.
they are ITS.
They are ITS.
ITS. So what, Your Lordship, that ITS also they have given affidavit that all the ITS, including the telecom, all have been reverted just to convince this the tribunal.
Necessity, they may have done so. It was only for non-ITS. It was only for non-ITS.
ITS, Your Lordship, they decided a strategy how to.
All right, this is okay. Now next, proceed to the next.
Now, Your Lordship. Thank you. And moreover, Your Lordship, para 6, Your Lordship, para 6, last day also hearing it was confirmed that it is not for ITS officer. There is no exclusivity. I have given some around 15 grounds that it is not an exclusive for ITS officer. It is open for all the officers. Now, I had also explained, Your Lordship, that this was a new inclusion in MSRR 23. It was not available in MSRR 2009, that the other esteemed officers also will be allowed in this post of CGM and GM and above level post. This was a deliberate, conscious, and intentional decision of the board that cannot be taken back by any DOT or any government. Also has no power, because it was decided. It has been decided by as per MSRR of BSNL. That is a rule under 309 article. So that rule cannot be taken away by the government by issuing some executive order by DOT, in the form of DOT ID note. And that DOT ID note also, Your Lordship, I have written twice this. I filed one MA before the learned tribunal to direct the respondents to produce the note sheet copy on which DOT ID note was processed.
Where are you posted now?
I'm posted at Chennai. So I had requested them to produce the note sheet copy on which DOT ID note was processed. That note sheet copy, in spite of learned tribunal direction, it was not produced. Then again, I asked under RTI Act also that you provide this document. We do not know what was in what case form the case was put up to Honorable Minister. Whether it was put up, the complete case was put up, he was apprised about all this merit-based process or not, or whether this whatever has been conveyed by the minister, the same has been conveyed in DOT ID note. That also needs a scrutiny, because that they have been concealing since a long time. And DOT ID note, moreover, is an instruction completely. They have written that MSRS is applicable to BSNL absorbed officer. It is not applicable to ITS officers. Nowhere they have written that DOT ID note is instruction for not for BSNL officers. They have clearly written in para. Your Lordship, I'll just go through this DOT ID note. What is DOT ID? Kindly 104, Your Lordship. 104, the third para. BSNL MSRR.
Mr.
We-
Chaudhary, you're appearing for respond number 2.
2, 3, and 4.
And who appears for 1?
One of them is. Actually, we are representing BSNL.
Then that's right. But who appears for the ministry?
I think Central Government Standing Council,
Who is he? Mr. Chaudhary.
Mr. Gupta.
Why were you sitting at the back? Arguments are now not being made on this. Arguments are being made against the department, against the ministry. When you are a respondent and you receive notice, otherwise also you are not a pro forma respondent. You represent the central government. But the case was not allotted to you.
Your Lordship, kindly come to page 930, annexure 2 of my rejoinder, 930. These are two, at point number 1, the information sought by me under RTI Act was, please provide the entire note sheet copy starting from the initiation of the proposal to the approval of competent authority leading to the issue of reversion order of CGM issued by the order dated 19/7/2024. At point number 3, I had requested the details, the detail of action taken by BSNL on receipt of DOT ID note dated
The
26.
reply is that it is too confidential in nature to be given to you.
No, Your Lordship, they are telling that presently the matter is sub judice in a court case filed by the applicant. The matter has not yet been attained finality, and disclosure of any details at this stage in the matter would jeopardize the interest of BSNL in the said
I will
case.
challenge this.
That means they are afraid that if this is disclosed, this will go against them. This is the interpretation.
The difficulty here is this. We cannot lift the wheel unless it is disputed. This is not a case of, corporate management where the courts can lift the wheel and see whether it is against the.
But Your Lordship, the Evidence Act of 1872, para 114G says that if something is not being
Or
produced,
suppose you had got that note sheet. The
Your
note
Lordship.
sheet would have said that yes, impanel these one out. And later there is another note which says that don't impanel them, that's a wrong interpretation.
Your Lordship, DOT has got no power to intervene in BSL matter. It's a autonomous PSU. They cannot intervene in HR matter. By formation of BSL itself, there was an understanding you signed that the autonomy will be given to BSL with the entire HR matter and other things. How they can start interfering in BSL matter DOT by issuing DOT ID note? Can there be two different standards of judgment for the same post? ITS officer will be posted as per the seniority, and for BSNL officer, they will be subject to such a rigorous empanelment process.
No. The rigorous empanelment process would be for ITS people also.
ITS people also, but they
are
are
being made CGM. When you make such arguments and you make a wholesale, attack, you are capable of being misunderstood. That we are keeping our minds open, therefore we are able to identify. See, it is not a question of your facing that rigor of the examination at 2 level and they not. No. They also, because not all the ITS officers at HAG or HAGNF level would automatically travel to the position of CGM. They have to undergo the same test.
Your Lordship, but duty ID note
this is
says,
only for them and not for you. That's the argument. You
Your-
say that no, this argument is incorrect.
yes,
You
Your
say
Lordship.
that this decision is incorrect.
Decision is correct.
Incorrect,
That
yes.
we cannot question now, Your Lordship. That just I am telling before Your Lordship to appreciate that point, but that cannot be questioned now. Only question is that DOT has got no power to intervene in taking decision regarding the absorbed officers of BSNL.
That's an ancillary ground with the ground that we stated. You're saying that this decision-making process is incorrect, and therefore it should be reviewed by the
If
division.
that was so, why this duty ID note was kept for 1 month without any action? So it was so urgent. And the overnight they processed, I had explained last time in the note sheet, overnight they processed and reverted all the officers. The note sheet was kept pending for 4 days with the CMD BSNL.
All right, anything else, Mr. Sashikant?
Your Lordship, many things are there which I wanted to explain.
We give you one more day, not for arguments. You note down in 5 pages, whatever ground you have to say, just give the reference of a rejoinder. We will consider everything. But we can't give you a hearing more than this. I mean, I think we have overstretched our time limits.
Much obliged, Your Lordship, that for patient hearing.
Now, do Mr. Sashikant one thing. I've asked him to provide all those pages in sequence. You also give all those pages in sequence with little, I mean, don't divert from the issue. You are now questioning. Now, after having said all this, you now question the correctness of the DOT's decision of interfering in the process of BSNL. Right?
Yes.
So you say that this is a very unreasonable stand and it goes against service jurisprudence. All right, you are entitled to question. But the difficulty here is this. Can we take up this matter in this petition?
Your Lordship, I'm
You're
not
understanding. You're not understanding what
What
we are saying. Yes. Therefore, the institution of lawyers, you have done your job very well. Not many advocates also, I'm telling you, I'm in presence of about 100 advocates or maybe 70 advocates here, that you have done your job, which very few advocates could have done. Correct. But then for understanding the finer nuances, you require that training of law, which your daughter has. Now, the question is that you are testing the decision of the government in interfering with the promotional process in BSNL, which promotional process BSNL carried forward with the approval of DOT. Correct. Because 94 says so. Now, suddenly brainwave comes to the department and says, no, it is wrong. Can it be done? That's your question. All. So on that question, if you have to say anything, tell us, but don't talk about Harendranath being posted there or somebody senior to him in CGS, ITS is reporting to him. That is not an
Your
argument.
Lordship, why I told that the instruction was to maintain seniority in duty.
Again,
So that is why I brought this issue.
instruction was to maintain seniority vis-a-vis the absorbed officers. How many times do you want us to tell you?
It is not written, Your Lordship.
Oh. See, it is not written, whatever is not written, you give your grounds. We will consider everything. Not a single ground of yours shall escape our attention.
Your Lordship.
Correct?
Your Lordship.
Because we take great interest. See, one person goes outside the court being dissatisfied, not with the judgment, but dissatisfied with the process of hearing. That is the failure of judiciary.
Your
I
Lordship, you
maintain
have
it.
made me so comfortable.
I maintain it.
must-
And therefore, despite stretching our time limit, when there are other very important matters, we have given you time on one day.
So
We have
much
heard you.
obliged, Your Lordship.
Today also we have heard you, but we can't enter into, repetitive arguments. So what you do is, you have understood what has been argued by him, what is our observation. You have understood our views also, that the way in which it was handled does not speak very well for the management at the top level. But question is that what can be done? That's the question. So we will consider that aspect also.
It will be very kind of Your Lordship. If I am told that specifically you will reply these points, I'll reply those points.
That is the point. But whatever he has argued, you just reply your point. This is your rejoinder is good enough. You have done everything. but formulate it in five pages today, give it to us by evening, we post it for judgment on Sunday.
Deep problem.
We will be waiting for Mr. Chaudhary and Mr. Shashikant to give your notes.
Yes, my lord, by 2 o'clock we are giving.
All right. Arguments heard. Judgment reserved. Give this photocopy. Give it. Would you be able to do it by tonight?
Lordship, one judgment was placed. I have not been given copy. What-
Copy judgment की नहीं दी जाती है. Whatever
I'll
is given
give
is the citation. Give him a photocopy.
I'll just now I'll give.
I don't have that copy of it. Lordship.
Para 5. Para 5. That's not with respect to ITS or anything. That's with respect to the question which was formulated in that.
Your Lordship.
Correct? इसको भी रखो. Zakir, keep this at the top. Don't miss it.
Item 3 and 4.
Yeah.
In this matter, I am seeking adjournment for 3 weeks.
No adjournment.
Lordship.
No adjournment, sir. A 1-day adjournment we have given you. You have not paid that amount?
Not yet. Also, it is very unfortunate, your lordship.
Just a minute. Don't be hyper about your rights. When the court is with you, why do you have to speak? Now what is we and we, this communication means nothing to us.
Lordship, it's a
This communication means nothing to us. That's not done. That's not done. So you're questioning only the compensation.
yes, Lordship.
Who the other appeal is by whom?
Other by the Director of Medical Education. Ma'am.
You are for?
I am for the Director of Medical.
What do you want to say? Tell us.
My lord, because there was a delay, my lord, in verifying the task data certificate, my lord.
And that's all right. But compensation has been given as a public law remedy.
Yes,
Correct.
yes.
So if public law remedy, if there has been some emasculation of fundamental right or any entitlement, the state as a constitutional entity, the department as a constitutional entity has to recompense,
Yes.
and courts can order that.
Yes.
When court orders it, it does not make it stigmatic on the government.
Yes.
It is like you see, suppose the compensation scheme under the criminal law, even if the case ends in acquittal, but if there has been a deprivation, the state is under an obligation to pay compensation. Here what has happened is correct. You wanted to maintain the time limit of Madhuri Patil. Okay, do I remember the facts correctly?
Yes, yes, yes. Yes, sir.
So this matter was argued. So Madhuri Patil, you followed genuine apprehension, and you were also genuine by taking help of CID or CBI or CID? CID. That the accusation of false certificate is wrong. You were genuine. So when the court asks you to pay 1 lakh rupees, the court is not imposing a fine only. It is a compensation. The student has lost. The student is he or she? He loses 1 year.
Yeah.
1 year is a big thing. He becomes junior to all. You see, all this fight is for seniority. What else? The time, please don't ask in this matter unnecessarily. Just now we said that institution of lawyers is such a great thing for judges. You understand? If you insist for time, we enhance 2 lakhs. We will put it after 2 weeks. But we'll say so for compliance. 2 lakh kar dein?
No, Lordship, then Lordship may fix it on Friday. Lordship.
Why Friday? Today? Why not today? Just now. It's a matter of 5 minutes. I will be dictating the judgment here. Where is the question? It's a limited concept that you've said.
My lord,
Am I being too harsh? No.
no,
Take it. Yes.
my lord, my appeal is that, my lord, the Director of Medical Education, my lord,
What is the direction of the court?
The direction of is not, my lord, it respondents to pay. State respondents, my lord, the specific portion at page 183, my lord.
Grant compensation accordingly, the state respondents are directed to pay an amount. Who pays, we are not concerned
Yes, sir.
between you.
But because we have provided the admission on the basis of the verification report, and if your lordship peruses
No, you.
paragraph
your
22, my
appeal is-
lord,
Just a
if
minute.
you're-
Your appeal-
for a moment-
दूसरा वाला appeal कहाँ है?
if your lordship peruses paragraph 22, my lord. Paragraph 22, my lord.
Of which appeal, sir?
Appeal number
366.
366 of 2025 by Director of Medical Education, Assam, my lord.
That's who has asked you? Who? We have not asked you. We have no. The judgment doesn't say the director of medical education.
Yes, my lord. That's why, my lord,
No,
my
no.
humble prayer is.
In this,
Lord,
it is appropriate to grant compensation for loss of one precious year. It doesn't say state respondent.
Yes, my lord. Then,
Apportion it amongst yourself.
my lord, if your lordship peruses paragraph 22, my lord. Regard being had to the claim of compensation after NGS consideration, this court is of the considered view that the petitioner is entitled to be compensated as the petitioner has lost one full academic year for no fault on his part. This court by the order dated so in WBC number so directed the petitioner to appear before the state level scrutiny committee on 16/10/2023 at 10:30 AM. On the consent of the parties and the petitioner appeared with all documents. The state level scrutiny committee held its meeting on 29/12/2023.
Where are you reading paragraph?
Paragraph 22, my lord, last page 183, my lord.
Paragraph 22 of the judgment.
Yes, my lord. Paragraph 22, my lord.
The state level committee on 16 at 10:30. The state level scrutiny committee held its meeting on 29/12. That is after 2 months. And 30/12/2003, after lapse of 2.5 months, and found that the genuine and communicate with the intent. Had the decision been taken directed by the court, the admission would not happen. Okay, that's correct.
My lord, so being
Factually correct.
the appellant here is the director of medical education. So on the basis of the verification reported, the admission has been
Recover it
provided.
from state. Directorate, it's a part of the finance department. You can recover it from the state. This, what is his name?
Kuldeep Tasa.
Kuldeep must get paid,
Yes, my
or
lord.
we will award interest on the compensation.
Yes, my lord. That is true.
Kuldeep must be paid.
But it should not be on the appellant, my lord,
We don't-
director of medical education, my lord.
No,
Because
there
my
is a specific, why, then you're seeking only quantum of compensation. Then where is this question of shifting the liability?
because my lord, there was no fault on our part, my lord.
You wrongly filed this appeal. In fact, if you had not filed, we would have said, then we will have to exonerate the state. Then you have to.
Because my lord, whenever the verification report came, my lord,
State get. Secretary, welfare of plain tribes and backward class. Both of them will share. Both of them will share because it is not basically your thing. Who appears for the writ appeal number? 366. Who appears in 366?
I'm looking. For the appellant, my lord.
Both of you apportion 50,000 each. Both of you must pay. In fact, as you're holding us back, we are tempted to award higher damages.
My lord, the director of medical education, he on
What is his name?
appellant.
Mr. Boda,
Yes, my lord.
you would ultimately have to pay through your nose higher amount. We are not concerned. Both of you should pay now. Both of you have come, both of you should. For 1 lakh you have come. Take them. The two appeals have been, yes, you want to say anything?
No, Lordship, I am only on the fact that it's very unfortunate that the state has come only for 1 lakh rupees. for the loss of one academic year of an MBA. That it is also your lordship view, your lordship. He has to run from pillar to post
For about 2
1 month.
months, for about 2 to 3 months in my professional career,
Okay.
I was representing the government as government pleader. Government pleader there is different. The standing counsels, the government pleaders, the government advocate, then advocate general. So early in my life, I was government pleader after 10 years of practice. And I was dealing with the finance commissioner who had to pay some amount, 25,000. And I told the finance commissioner that should we be filing appeal against this? He said, let it be a matter of 1 rupee. 1 rupee. We must contest it. That time, the law had not crystallized like this, that this public law remedy compensation does not stigmatize you. Right. So they have rightly done it on their part. They should have avoided. But if they have done, we will not question them.
No.
We will only reject their appeals. So there is nothing unfortunate about it. In fact, you should have come up with a separate petition that 1 lakh is too less.
Less.
The quantum is very less.
Lord.
Correct.
Lordship.
So you have not done. So be happy. You have taken admission. You are just late by 1 year, which is a big thing.
Lord.
Which is a big thing. Take note. These 2 appeals have been preferred by have been preferred by the Director of Medical Education Assam and Principal Assam Medical College, as well as by State of Assam, represented by the Secretary to the Government of Assam Welfare of Plain Tribes and Backward Caste Development, Dispur, Guwahati, against the judgment dated 7/3/2024, passed by a learned single judge of this court in WPC number 7103 of 2023, directing the respondents, that is the appellants herein, to compensate the writ petitioner with an amount of rupees 1 lakh as compensation for delay in making a decision, which led to the writ petitioner losing 1 year in his medical education. We have heard Sri D.P. Bora, learned advocate, in appeal number 366, उसको respectively ऊपर मिलना 366, and Mr. R.M. Das for the appellant in WA number 378 of 2024. So we have also heard
F. Hussain.
MSF Hussain, learned advocate for respond number 1/writ petitioner. The writ petitioner, a student hailing from tea garden laborer / ex-tea garden laborer category, which is the reserved quota for other backward classes in medical admissions, had appeared for the NEET UG 2023 exam, in which his score was 417 marks. So based on that score, he was provisionally selected for a seat in first year MBBS course at Assam Medical College and Hospital, Dibrugarh, under the quota of OBC. He had taken admission on the basis of provisional list issued by the Director of Medical Education. However, shortly thereafter, his admission was cancelled on September 28 and 29. Was cancelled on 3/9/2023. Holding that the OBC certificate furnished by him was either false or fake. The matter went in litigation, and ultimately, with the direction of the court, a verification exercise was made to find out whether the writ petitioner really hailed from the OBC category and had furnished correct certificate. The respondents / appellants herein, taking the aid of CIT, taking the aid of Criminal Investigation Department, made a verification and found that the certificate of OBC in favor of the petitioner was genuine, and that he was rightly allotted one medical seat in the Dibrugarh Medical College, in the Assam Medical College, Dibrugarh, on the basis of that quota. However, in the process, the writ petitioner lost 1 year. However, he was admitted to the medical course in first year in the 2024 session. The learned single judge, after having dealt with all the facts of the case, found that the writ petitioner was entitled to be compensated and therefore directed for payment of an amount of ₹1 lakh within 6 weeks of the date of receipt of the certified copy of the judgment, which has been impugned in the present set of appeals. The appellants in both the appeals do not question the judgment on its merits, as the facts stand established that the writ petitioner hailed from the OBC quota, under which he had been admitted in MBBS course in the session commencing from 2023, but wrongly, on an accusation of the certificate furnished by the petitioner to be fake and false, his admission was cancelled. The position could be restored only after the court-ordered verification exercise, wherein the certificate was found to be correct. Thus, both the appeals aim at questioning the quantum of compensation which has been directed to be paid to the writ petitioner. Mr. Bora, in criminal appeal number so-and-so, in writ appeal number so-and-so, has drawn the attention of this court to paragraph 22 of the impugned judgment, which reads as hereunder. Paragraph 22 extract. He therefore submits that in the estimation of the court, 1 lakh compensation was the amount which would have been a kind of recompense to the writ petitioner. But there was no necessity of holding the appellant, namely the director and the director of the medical education and the principal of the college, to be responsible for the delay in making the verification, which ultimately led to the loss of 1 year for the writ petitioner. He therefore submits that the quantum of compensation, even if paid to the writ petitioner, ought not to be taken as a stigmatic on the conduct of the appellants. On the other hand, Mr. Das, learned advocate for the appellant in 378, appeal number 378 of 2024, submits that the writ petitioner could not be admitted in 2023 course for the reason that the verification with respect to his caste certificate, which was the basis for admission, took some time, and the session could not have been delayed because of the directions of the Supreme Court in maintaining the academic sessions in technical colleges, including medical college. So in any view of the matter, the sum and substance of the argument of Mr. Das is also saying that the compensation amount, if paid to the writ petitioner, ought not to be held as a castigation on the conduct of the appellant as a state. Compensation, next, compensation is a kind of monetary redress granted by the constitutional courts for violation of हम उस दिन निकलवाए थे नीलावती बेहरा versus state of, I don't know, Nirod had taken it out. That day when the matter was heard, Nilavati Behra versus State of Orissa, 1993, 2 SCC 746. It is there. Mangal. What have I said? For violation of legal or fundamental right of an individual by state action or inaction, it is distinct from private law damages, which require the proof of negligence or perhaps the tortious acts. It is also different from ex gratia relief, which is discretionary or policy based. In Rudulsa versus State of Bihar, 1983, 4 SCC 141, it was for the first time that the courts laid down that Article 32 and Article 226 of the Constitution of India empower the constitutional courts to award monetary compensation as an appropriate and effective remedy. It might not depend. It does not depend. The award of compensation does not necessarily depend upon the proof of malafide. or negligence. The state as a constitutional entity is responsible for the acts of its instrumentalities, which actually ends up either in deprivation of life, liberty, or any lawful entitlement of entitlement of citizen. In the past, the courts have directed for compensation to be paid as an effective recompense for the deprivation of the entitlement in cases of illegal detention, death because of police beating, or in any other form of custodial death. Next, also refer to bracket करना नीचे में, also refer to Sebastian M. Hongre versus Union of India, (1984), 3 SCC 82, semicolon, Bhim Singh versus State of J&K, 1984, supplementary SCC 504, Saheli, a Women's Resources Center versus Commissioner of Police, Delhi Police Headquarters, 1991 SCC 422, and State of Maharashtra versus Ravikant S. Patil, (1991) 2 SCC 373. Next, since in both the appeals, the learned advocates representing the appellants have questioned the determination of the quantum of compensation, it would only be necessary to expatiate on this aspect as well. In such cases where compensation is awarded as a public law remedy, the issue of quantum of compensation so awarded is not arrived at by any fixed formulae. The whole purpose would be defeated if the award of such compensation is made formulaic. It depends upon the nature and extent of injury, whether physical, mental, reputational, or resulting in loss of opportunity. In the present case, it was mental and reputational both, as the very genuineness of the caste certificate furnished by the writ petitioner was questioned as being non-genuine. The quantum has also to depend on the duration and consequence of any action or inaction of the state leading to the physical and mental injury. First off, it is also to be considered in the context of the conduct of the authorities. The learned single judge in the present case has found that despite the order of the court, 2 months were taken for verification of the correctness / genuineness of the caste certificate of the writ petitioner. Seen generally, for a state in its instrumentality or agency to arrive at a proper decision in 2 months is not something unusual. But in the present case, it has resulted in loss of 1 full academic year of the writ petitioner, which cannot be recompensed otherwise. This monetary compensation of 1 lakh is only a solace and does not form part of any retributory exercise by the learned single judge. The restorative purpose for which the compensation was awarded is clear in the judgment. No stigma has been cast, no responsibility has been fixed. It also depends on the socio-economic impact on the victim. The writ petitioner hailed from other backward caste, which because of its less representation in medical institutions, was given reservation, and the writ petitioner rightly and genuinely availed of such concession. It also needs to be explained here that the defense of sovereign immunity is inapplicable in cases of violation of any right or entitlement. The appellants, therefore, cannot claim that because it was necessary to verify and examine the genuineness of the caste certificate, the delay had occurred, and for that they can't be held responsible. Such this deprivation of a citizen for any state action or inaction, as noted above, is to be dealt with by applying the principle, by applying the doctrine of strict liability fastened on a state. With this evolved jurisprudence, we find that the compensation awarded to the writ petitioner is just and reasonable. The courts have awarded compensation for such loss of academic year to students ranging from 50,000 to 2 lakhs. We therefore do not find any merit in the challenge of the appellants with respect to the quantum of compensation awarded to the writ petitioner, when there is no specific fixing of guilt or responsibility of any one of the agencies of the state, be it the Directorate of Medical Education or the state in its Department of Tribal Welfare. All that we would care is that without any delay, the amount of compensation be paid to the writ petitioner / respondent number 1, failing which, paid within 4 weeks from today, failing which, a serious view of the matter would be taken on a 2 pages affidavit made by the respondent number 1, which would revive this appeal, which would revive both the appeals for further consideration. Both the appeals stand disposed of accordingly. Pay her within 4 weeks, or else we award 5 lakhs and we fix the responsibility.
Item number 7.
Yes, Mr. Advocate General. Oh, you had to argue or you had to argue?
I think I have to look.
Okay.
My lord, the state has come up with that.
Just remind us of what had happened on the last
My
occasion.
lord, actually, in terms of the Supreme Court judgment, more particularly in the review,
Vishwanath.
Vishwanath, those who have, my lord, 18 months diploma and those who are on service on a particular date, that is 10/8/17.
Not all 18 months. With that particular
Yes.
appointment advertisement.
Yes, yes.
Correct?
Yes, they are eligible to apply. Now, my lord, now the present dispute is, in spite of the Supreme Court clear direction, state has come up with a notice whereby, apart from the 2 requirements of having the diploma and being in service on 10/8/17, we are also supposed to, my lord, satisfy the authority regarding our above status by way of furnishing certain information. We say these are all onerous and these are arbitrary. Now, why we are saying so, my lord? We have filed an additional affidavit.
Have you given
where-
a copy to Mr. Saikia?
Yes, long back, my lord. Now, if your lordship would kindly come to that additional affidavit at page number 461.
Is the same affidavit which says compilation of document.
No, my lord, it is in a separate additional affidavit filed in the writ appeal. And the running page, it starts at page number 451. I'll have your kind attention to page 461, my lord. What process we had undergone while, my lord, applying for registration, that itself will satisfy that, my lord, we meet all the requirements. There can be no manner of doubt that we were in service. If your lordship would kindly come to page number 461. The heading is National Institute of Open Schooling, NIOS portal for online registration and monitoring of the untrained in-service teacher. Now, if your lordship would kindly come to page 462. A 1.1, registration by untrained teachers having UDICE code. We do not fall in this category. Now, my lord will kindly come to the next page, 463. 1.2, this is important as far as we are concerned. A registration by untrained teachers without having UDICE code. So teacher will register by providing the following information, etc., etc. Then my lord will kindly come to page number 464. 1.3, amongst others, my lord, entry by the untrained teachers. If your lordship would kindly come to Roman 17. Date of appointment, day, month, year. Then my lord will kindly come to page 465. 2.2. a registration by principal of the school without having UDI's code. So basically, it is the duty of the principal, my lord. Then if your lordship would kindly come to page 466. 2.4. Authentication of teachers' record by principal of the school. All the data of teachers registered with this UDI's code or with the same school name of which he is principal will be displayed in a grid form with authentication button. Then my lord will kindly come to the next page. 3.2 and 4. Login by the state nodal officer. Once state nodal officer registers, then she can log in into the system by providing the email ID and the password given during registration in the previous state. Now this is important. The state nodal officer can view all registration data of untrained teachers of the particular state. The data can be viewed district-wise. Then it is followed by, my lord, MIS report. Based on the above registration data, various MIS reports will be generated. Now it could be state-wise, district-wise, it is district-wise, school-wise of untrained teachers. So, my lord, while we registered for the diploma, my lord, we have undergone this, which clearly reveals that we were in service on 10/8/2017, and there is no dispute that we have 18 months diploma. So, in this situation, my lord, whether the further prescription now which is thought to be envisaged by the state can be said to be a reasonable or a rational exercise of power. So this was the process we had undergone while seeking registration. It is in this situation, my lord, I made my submission on last occasion also. Per se, the prescription in the impugned communication of 17/6/25 may not appear to be arbitrary. But if we look at the background, attending facts and circumstances, my lord, it is really unreasonable. Why we are saying so, my lord? I'll just give you examples. If your lordships would kindly take my writ appeal, my lord. Please come to page 17, my lord. Or rather, page 18. Page number 18 in the writ appeal, my lord. Please come to the first subpara. It is pertinent to mention that at the relevant point of time, certain schools, particularly in case of appellants, about 68 did not possess permanent UDI codes. In such instances, specific one-time UDI codes were generated by the concerned block elementary education officer. Government of Assam, under the direction of NIOS, after conducting necessary verification of service record and field inquiry. These one-time UDI codes were thereafter used for registering the appellants in DLED course. However, for reasons best known to the respondent authorities, those particular UDI codes have since been deactivated, rendering the corresponding data inaccessible to the appellant. Consequently, although the
We
appellants were
remember Advocate General making an objection that if it has been deactivated, you would be having the number of UDIs. The number, code. You must be having that number.
yes, my lord, there
What
are
is
three.
that number?
There are three categories. I'll give the example, my lord. There are three categories of person. First is, my lord, it was auto-generated and schools are running. But there is no record. That is one category. Second category is, my lord, cases where school have UDIs, but records not uploaded in the UDIs data. Then the third category is, I'll give the example, my lord, I brought it. That UDIs was auto-generated, but school is closed. Now, for example, if your lordships would kindly take the writ petition for a moment, my lord, I'm giving an example of appellant number 15. She is Jyotismita Haloi.
No,
Please.
who appears for NIOL?
Notice has been issued, sir.
Notice has, no notice has been issued, my lord, till date.
NIOS will be having the.
Yes, measure says. They will have their measure say in this case.
NIOS is a central government agency.
Yes,
We can ask the central government, Mr.
yes, standing council can, yes.
Please, Mr. Advocate General, could you please send in for the
Yes,
central government standing up?
I said,
Now, we want the main person.
yes, my lord, they're necessary part.
Ready, he'll be just part, necessary part. Mr. Gupta,
In respect of NIS, there is a standing council also.
they have a separate standing council.
Lordship.
Who is he?
R. Bora, Ranu Bora.
We call him. Can you just, Mr. Gogoi, can you do this work for the court? We will hear at 2 o'clock.
Okay.
Item 7.
Yes, central government council.
There is a change of council, she is coming, okay. Rita Borua is newly entered as the council on this, she is completely on the way.
Who is the council?
R. Borua, Rita Borua, she is on the way.
All right. Yes,
Yes. My lord, I have now, my lord, just to substantiate from what I says come.
Rita.
we know that you have not been noticed, but then you are one of the respondents. Are you aware of the facts of this case?
No, Lordship, just now director has instructed me to appear, Lordship, just now.
Just now, the director of NJIOS.
Ah. Let me give some time.
You do one thing. You just find out from the NIOJS, what is it?
NIOS.
National.
NIOS office
Yes.
about the registration process and whether they keep the records. Right. This is with respect to some of the aspirants who have only 18 months of diploma, which has been permitted by a Supreme Court judgment. But then the state, to a large extent, rightly says that we need to verify whether these are the persons who are real, 18 months diploma holders while teaching in a school. Now, anybody can't. And you don't even permit. You'll have to go through the brief. Otherwise, it'll all appear very abstract to you.
Lordship.
But
Lord, what we can do-
the matter is urgent. You find out and tell us next week.
My lord, what we can do, we'll supply a set of the writ appeal.
Please
Today,
take down.
or tomorrow morning at 10:30 we'll hand over because it'll bulky paper.
Yes, Mr. Arvind.
I would like to make a small submission.
Yes.
Now, in the writ proceedings, a particular pleadings were there. They filed a writ appeal without the basic document,
Yes.
which also Lordship has condoned. Now they
No,
want
we
to,
have not condoned. We will take it into account.
yes, okay, Lord. Now they are bringing some additional affidavits, whether they have taken the leave of the court or not, because that is not permissible. I have series of judgments on appropriate time I will place that if new facts are to be brought at the level of appeal, intra-court appeal, then there has to be a leave granted by the division bench, which they have not done till now. If Lordship gives them the leave to bring the additional facts, then Lordship will give us notice, then we can rebut by filing a counter affidavit.
That objection is sustained.
Deeply obliged.
Take down.
I just need 5 minutes if my lord would
There is a division bench judgment of our High Court, my lord. I made this submission. This was rejected. and new facts can be brought in because it is not, it is only an intra-court appeal. It is continuation of the original
But then
proceeding.
we have to give some.
Yes,
time.
yes, but
Even
just point of
All right,
information,
so
yes.
post-
I'll place that judgment, Miller.
Post filing the additional documents,
Yes,
which are not part of the writ record,
yes,
we have to give them time, no?
of course. And we have served these copies when? At the filing, they could have filed a reply to that. They have not filed till. It
That's
is not
all
that
right.
we have
Then
not served them a copy.
Mr. Advocate General raises a preliminary objection, so
Yes.
we accept this affidavit for a proper determination of the case, and we grant you post facto leave with the
Yes.
liberty to the Advocate General to
I
respond.
was not sure whether they are going to praise it or not. Today they have praised
No.
it. So I have raised the objection
No, no,
at the appropriate time.
Mr. Saikia, we have sustained your objection.
Highly obliged, Lord.
Even otherwise, the matter will not be heard.
Well,
today.
this
Will not be-
expression sustained, we often come across in Hindi movies, my lord. Objection overruled.
I have used this expression after 10 years.
But we enjoy that expression when we see it in the movie as well as in the court.
Can I just take 5 minutes of my lord's time if my lord would permit?
Yes, what do you want to say?
Well, there are about 6 applications listed today, and I had the privilege to assist the learned single judge in this very matter, my lord. The Honorable Supreme Court had passed the order, my lord. I just need 5 minutes by watch. I'm not taking my lord through any of the documents, but just wanted to give a brief background because the Honorable Supreme Court, I had the privilege of assisting the Honorable
That's
Supreme
all
Court
right,
also in the very same matter.
Mr. Kalra, you address us on the next date.
Yes.
Today-
Can I
today-
just take 2 minutes, my lord? Can I just take 2 minutes?
That would not be necessary. On the next date, we'll give you 20 minutes. Don't worry.
Very well. My lord, then my lord may kindly be pleased to issue notice in my application because these applications are for impleadment because some of the parties were there before the single judge and
That
some
will
are
be-
similarly placed.
That may not be necessary. We'll decide it on principle. That may not be necessary. We will decide it on principle. We will
Very
deal
well.
with your IA. We'll deal with your IA, no doubts.
Very well. Very well, my lord. And there is one last thing that I wanted to say if my lord would permit. I had mentioned on the last day, my lord, that after the learned single judge's order, there has been another judgment of the Honorable Supreme Court in the very same issue, where the Honorable Supreme Court has observed that relying upon one document, which is an experience certificate as certified by the Government of India.
You had said that on that
is-
day. We remember.
Yes, my lord.
You had said that.
That needs to be taken. And the last thing is, my lord, some interim prayer today needs to be considered, my lord. The reason is this, my lord, that most of the appointment letters have already been issued by the government.
No, we have already
Now,
made
today
it subject. We have already made it. Any future appointment letter will carry that caveat.
That may be continued, my lord. That interim protection may be.
Unless we resigned it, it shall continue, Mr. Kalra.
Very well, very well.
Don't worry about that. See, question is this. Now, we also must get satisfied that you people are genuine people who would require this kind of concession.
Lords, I will
Now,
show
if
from the
you-
documents.
That's
I will
right.
show from the
We are
documents
not,
that
are we,
this verification,
Mr.
this
Kalra, are we
verification.
Mr. Kalra, are we
Very well.
concluding today? We are not. We are not
Very well.
concluding today.
Very well.
See, because the past experience has not been good. Past experience of the governments have not been good, especially in the Department of Education. And
I
therefore,
understand that.
utmost care has to be taken with the balance that
I understand that.
person who deserves to be considered, he can't be shut out. So therefore,
I understand that, my lord.
let
Just
me-
one
let-
thing, if I can add. If one
let
thing
me
I can
first-
add.
Mr. Kalra, you are too full of the facts of your case. We understand that. We appreciate that also. We appreciate it, but then just don't take out, bit by bit from your sleeves. We will jot it down at one place, and when we give you the opportunity to address us, with an open mind, we'll be hearing you. All right?
Very well, my lord. So grateful.
No, I said, don't take it out from your sleeve every now and then. Huh? Take care. During the course of hearing of this matter, of these set of appeals, we realized that NIOS, though has been made a party, was not noticed. We sent for the Standing Counsel for NIOS, who has presented herself before this court and has submitted that she would be taking instructions with respect to factual averments made in the appeals and shall get back to this court by the next date. A copy of the main memo of appeal along with the annexures shall be handed over by Mr. Ken Chaudhary, learned senior advocate, leading the arguments on behalf of the appellants to her
By
during the-
tomorrow at 10:30.
by tomorrow at 10:30, by tomorrow morning. Mr. Chaudhary, while addressing this court, also referred to certain additional affidavits, also referred to an additional affidavit filed before this court in this appeal on
They took 13 October 2020.
13/10/25, Miller.
on 13/10/2025. The learned advocate general raising objection to the maintainability, to the admissibility, learned advocate general, the learned advocate general, however, submits that without the leave of the court, these additional facts and documents could not have been brought on record. And if at all, any ex post facto leave is granted for bringing those affidavit, by bringing that affidavit on record, the state shall have the responsibility, the state shall have the liberty to rebut the factual position. Be that as it may, the additional affidavit, the contents of the additional affidavit are not yet fully known to us. We, for reasons of effective determination of the dispute here, permit it to be taken on record. And we simultaneously grant liberty to the learned advocate general to rebut the facts stated therein, if so desired by the next state. The issue pertains to the eligibility of the appellants for being considered for appointment to the post of teachers, especially in view of the fact that they have only 18 months diploma instead of 2-year diploma in elementary education. By virtue of a judgment of Supreme Court in its review jurisdiction, in the present appointment process, such candidates having 18 months diploma from national, what is NIOS? What is the full form?
NIOS.
National Institute of Open Schooling, ma'am.
National Institute of Open Schooling.
Open Schooling.
Open Schooling, bracket NIOS. What did I say? I couldn't get the link line. Start from. In the present appointment process, are permitted to participate. However, the state in its education department has asked for further confirmatory facts relating to their entitlement as aspirants for the said post, which is being opposed by the appellants, which objection was turned down by the learned single judge. Hence this appeal. It is in this context that we would require effective assistance of MS
RB Bora.
RB Borbora or RB Bora?
RB Bora.
RB Bora, learned standing counsel for the NIOS, especially the fact whether NIOS maintains or has in its records the names of the schools with their UDISC code, even though temporarily granted, in which the appellants were employed as teachers when they were recommended for 18 months diploma course. the details of the records of such teachers who obtained diploma, 18 months diploma, if available, ought to be brought on record by the next stage. Re-notify.
Only one thing. Now NIS has been asked to give the credentials of those schools. Their schools are not proper. They have to properly identify those schools.
And that will, but provided, see, question is that you are asking for those details. They say that it was deactivated. Now,
Or
if-
which school?
So therefore,
X may be a school,
therefore,
whether that X school has been
like,
deactivated or not.
so unless they have the record of that UDISC code number of such schools whose teachers were permitted, I think they don't have a case.
Yes.
Then it-
No,
it
Lordship,
would be-
we,
it would be
in
required-
Assam, we have 45,000 elementary schools. So whether all the records of those schools will be required
No, no,
in this
no,
evidence.
no. Records which are essential. You have learned it. It is with respect to these appellants.
Who are the appellants?
Appellants only, for the appellants. Just write for the appellants will.
Well, the applicants as well, my lord.
Appellants / applicants.
I'm so grateful.
But they have to identify their, because
Yes.
they have to
That-
identify
see-
their schools.
See, if you have the, Mr. Chaudhary, even if it has been deactivated, we would like to know whether you were teaching in the school. May anybody
Those certificates are there, my lord.
Point number 7 is there.
All right.
And my lord, I'll address your lordships on that.
All right.
Next week.
Next, when do we place it?
Depending on,
I need 4 weeks time. Because they have mentioned about 68 schools, we have to find out the credentials.
All right. So
I think 4 weeks will be too long, my lord. Let it be.
interim, all appointments made shall be with a cabinet.
In our appointment order, we have very categorically mentioned that.
And it was offered on behalf of the Advocate General only. We didn't have this idea. He only said that it will carry that line.
Yes, Lordship,
Instead of
which
4
would be
weeks, my
fair.
lord, let it be 2 weeks or 3 weeks, my lord. End of the day, my lord, these are all contentious matters.
These are, but we will keep it as first case on the reopening after winter holiday.
Let it be in December, my lord.
All right. December first week, this bench is not available.
Second is, my lord.
Second week, they'll not be ready. And third week again, I'm not there. Anyway, we keep it on 18th of December.
So from 14 to 18, I am not available. 19th or 20, whatever it was.
19 is the last working.
19th, let it be 19th.
19th, you'll be here.
Yes, Lordship.
Last day when the court closes.
I'll
for
come,
the day.
Lordship. No issues, no difficulty.
Can we pray?
Can we not keep it in the first week of January?
I have no objection.
First week, January is all closed here in Assam.
No, I'll be here, Lordship. I mean, if
Lord,
the
if
court
it
is
is-
open, I'll be here.
If it is otherwise not inconvenient, could it be on 8th of December, my lord? Side one, while time loga.
8 week we are open. 8 week, can you collate all the information
Yes.
by 8?
If she is not in a position,
MS
lordship will accommodate her.
To a 12th of December, Lordship, if it is not inconvenient.
All right, 12th of December.
Grateful, my lord, deeply grateful.
Item number 8.
Lordship, this is a appeal preferred by the state. Lordship, I have 3 hearing matters, the Muslim Marriage Act also. So I prepared that and this one. So this matter may be adjourned for the day, Lordship.
Only adjourned for the day.
Only adjournment for the day, Lordship.
But tomorrow.
Day after tomorrow, it can come, Lordship.
There's some difficulty, Manoj, on our part, Manoj. I'm led by Mr. I. Chaudhary, Manoj. Yes, some difficulty, Manoj. May I pray for sometime in December, Manoj?
No difficulty in the first week of December if it is not inconvenient.
11th, Manoj.
Because this case was prepared by
Please avoid asking for first week if it has to be heard by this bench.
11th.
Both of us are not available.
11th December.
11th December or maybe on 14th of December or 18th of December. 19th of December, sorry.
All right, 19th of December.
19th of December.
As prayed for on behalf of the appellant state, re-notify on 19th of December.
This is one of the last case prepared by my Lord Justice R. Mujumdar.
Okay.
Deeply obliged.
Supplementary list, item 27.
May I please, Lord, sir?
Yes, Mr. Kal.
Lordship, here, Lordship, respondent number 2, file an application under 95 before the company law tribunal, Lordship. We, after receipt of notice, we file an application under section 60, clause 5, changing the maintainability of the petition, Lordship. That was admitted, but Lordship, on 6th of October, Lordship, the matter was heard. But without deciding our application, they appointed the resolution of
Without deciding your maintainability question,
Lordship.
they have decided the application and section 95 has been invoked and
Yes,
a
Lord.
resolution professional has been.
Yeah, appointed.
Will issue notice in this matter.
Lordship.
Let notice be issued. 2.
Respondent number 1 is a central government, Lordship.
That you don't want.
No.
Let notice be issued to respond number 2. Any lawyer representing Indian Bank?
No, Lordship, no. Indian Bank, Lordship, there is no standing counsel.
SLE, take that. We have heard Shri Kayal. We have heard Shri S.C. Kayal, learned advocate for the writ petitioner, who seeks to challenge the order impugned dated 6th of October 2025, passed by the National Company Law Tribunal, Kolkata.
Guwahati, Lordship.
National Company Law Tribunal, Guwahati.
Page 16. Lordship.
Just a minute. Wherein, without deciding the maintainability of the application on grounds of territorial jurisdiction and on other
Lordship.
grounds, an order was passed invoking the powers, invoking the provision of section 95 of the Insolvency and Bankruptcy Code 2016. And a resolution professional has been appointed in the matter. Let notice be issued to respond number 2 on steps being taken by the petitioner within a period of 2 weeks.
But tomorrow we'll take step.
Within a period of 1 week, both modes returnable January.
Lordship, I have a
8th of January.
interim prayer, Lordship, because the matter is fixed on 14. Lordship, if it is not stayed, then Lordship,
Resolution professional will do what? He will issue notice.
he has taken over the issue and he has issued notice to us to provide some documents. Lordship, if
Then you do one thing.
Lordship.
You have been issued notice by the resolution professional. The Supreme Court says in many judgments
Lordship.
that this invocation of section 95 ought not to be interfered with normally, because basically it deals with resolution under the Insolvency Code. Then in that case, you serve the notice and we will hear the other side and then we shall pass on. We will give you a short date.
Lordship,
Nothing is going to happen.
on Monday, Lordship.
So you, as a legal, let notice be issued to respondent number 2 on steps being taken by the petitioner by tomorrow,
Lordship.
returnable on 15th of December. 15th of December.
Lordship,
You want dusty notice also?
Lordship,
You want dusty notice also?
Lordship, will serve.
Dusty notice also shall be served on respondent number 2 on requisites furnished by the petitioner by tomorrow.
Lordship, we may be given liberty to approach the tribunal with the order passed.
Who stops you?
Lordship.
Who stops you, Mr. Kayal?
Lordship.
But the reason is that section 95 order, without the presence of the other side, we will not stop it.
But Lordship, here we have challenged the jurisdiction of the
That's
tribunal.
right. We will hear you.
Lordship.
We will hear you.
Daily list for hearing, item 9 and 10.
This is death sentence in general. Mr. Bhuyan,
Yes,
today we can't hear you. We will not start the arguments today.
my lord, may I?
Reason that this court has to rise at 3 for reference of an ex-judge, a judge who is
My lord.
a retired
Yes,
a judge who has passed away.
my lord, what I am on, my lord, there are 46 witnesses here. Now, here in this case, with regard to the judgment that has been passed, it's been reflected in the judgment that juvenility was never taken a ground.
So,
But here, my lord, some only few witnesses, 3-4 witnesses, my lord, from where the court has interpreted him to be a major, wherein the evidence on record says so, my lord, the 313 statement, the defense witnesses,
Mr.
that,
Bhuyan, you know the law, no?
yes,
You are supposed to know, and we know that you know the law.
yes,
So this point could be raised at any point. any
absolutely.
time.
So we are raised here before this honorable court in the appeal. If your lordship is been satisfied from these particular witnesses' depositions only, not going into the merit, that it's a case wherein, my lord, it has to be remanded back
No,
for
no,
ossification.
No, no. Mr. Bhuyan, again, I'll tell you to go through the law with respect to this. Right from Ranvijay Singh's.
Yes,
Ranvijay, I had the occasion to appear at one point of time. Therefore, it is very fresh in my mind.
yes,
It all started with Ranvijay. And then, proliferated. All this change in the law came about with the judgment which had traveled from Patna High Court.
yes,
A doctor's son was made an accused.
yes,
And then the person who was killed was grandson of a Supreme Court.
Yeah.
That was the case. So now the law now with the change in the statute is this. And the case laws also will tell you that it can be done at any time. This what you're saying, inferential facts from the deposition of witnesses, that's not what the judgments say. That is only with respect to determination of right of private defense at any stage from the evidence collected.
Right.
This has to be specifically pleaded. You have a liberty to plead it at any stage,
yes,
even in the Supreme Court,
yes,
after the judgment of the Supreme Court. That you can always do, but not this way. If you say so, you can file a petition here that this is our, we grant you time, you can file a petition
yes, my lord.
with supporting documents. In that case, we will.
My lord, he have never been to school, my lord.
But not on the basis of inference from the evidence.
My lord,
You have
what I
to
am
plead
on,
it specifically.
my lord, as per the law that's been laid down by the apex court, my lord, wherein a person doesn't have a birth certificate, never been to a school. Now here is a case wherein he is never been to a school, and he.
That's true, but we will consider your application only when we are satisfied that yes, this is a matter where inquiry should be made whether he was juvenile on the date of the other.
My lord, my lord. Because the father have adduced evidence, he's 313, he stated his, my lord, date of birth.
Those are stray statements.
Yes.
I mean, we would not take anything specially. In that case, you will be on a weak wicket. And you have not filed any application.
We have taken a ground in the appeal memo, my lord.
No,
with regard to-
ground is irrelevant. You have to file an application. You can file a petition.
We'll
here.
file a, we'll
There's
file.
a special knowledge which is in his knowledge, man.
All right, and bring all the case law.
Yes,
With respect.
yes.
Take it. Let both the matters be taken up for consideration on first week of January. Mr. Bhuyan, learned senator. Mr. Bhuyan, learned advocate for the
Appellant.
appellant / respondent in the death reference submits that he shall be filing a requisite application with respect to the juvenility of one sole accused.
One.
Juvenility of
The appellant. my lord.
the appellant herein, which ground was never taken up till now. Let that be done by the next date.
Well, we have also appeared, I am as an amicus.
Yeah, give me amicus, yes. Mr.
I am Z Kamal, my lord.
Yes, we have only.
My lord, that.
Yes.
Kabul.
6 January. Item number 15.
My lord, this is a matter. Lordship need not take the trouble of reading the brief, my lord. A particular road construction contract was awarded to the petitioner. Then, my lord, midway, the work was terminated and it was given to another agency.
You have impleaded him.
No, Lord, then I filed a writ petition before the learned single judge. The learned single judge, my lord, did not interfere with the termination of the contract. But learned single judge, having noticed that there are a lot of irregularities, directed an inquiry. Now, inquiry was conducted. Whatever allegations we brought out were found to be correct. Now, eventually, my lord, Now the remaining part of the work has been awarded to the petitioner. In other words, the learned single judge's stand in not interfering with the termination part stands, my lord, redundant now. Because now department itself has awarded the balance contract to the us. Only thing is, my lord, this work. Yes,
Then withdraw this.
that's right. But the only, I'll withdraw, my lord, because of this. Only thing is, my lord, on 19/8/25, resumption of work order was given by the concerned executive engineer. But till that, my lord, they have not been allowed to work. That is what, my lord. That only PWD council can clarify that, my lord. Please come to that 19/8/25, my lord. Third page of that compilation. Resumption of work. Now, last para, in view of above, you are requested to mobilize resources, workforce at the earliest, and intimate this office regarding the date of resumption of work. You are requested to make necessary arrangement, submit fresh work program, expedite, etc., etc.
Therefore, the ball is in your court, Mr.
Yes, it is in my court, my lord. I am trying to start, my lord, for somehow I am not getting the.
Then perhaps again this will be questionable.
No, my lord, there's nothing like it. Once they have
Why
issued.
don't you complete?
This was my prayer in the writ petition partly, which was, that part was rejected. Now, my lord, they themselves just found during the course of inquiry that all my allegations are correct. In fact, my lord, the executive engineer who, my lord, terminated the contract.
Resume the work.
Yes, I'll resume. Only that observation.
They are not going to do anything. If they don't give you, you say that they have not given.
Or lordship shall observe in terms of the order, I'll resume my work.
What more resumption order do you want? They have said so.
Yes.
Mobilize your resources,
Or
intimate.
in terms of this order, we are withdrawing the appeal, my lord.
Let's take it out.
No, no, yeah.
We have heard Mr. Kane Chaudhary, learned senior advocate for the appellant, and Mr. T. Nath for the respondent.
Logic.
The appellant was awarded the contract for construction of a road under the Pradhan Mantri Gram Sarak Yojana, bracket package number AS 13278. He made substantial, he carried out substantial construction, completing approximately 5.3 kilometers of road out of total of 5.43 kilometers, which was never disputed. However, during the period when the pandemic had set in, the work was slowed down, by which time the contract period had expired. It was the case of the appellant that despite several reminders to the respondents for extension of time for concluding the contract work, no order was passed. However, to the dismay of the appellant, sometimes in December 2020, his contract was terminated, saddling him with a penalty of 20% and with a direction to cease work immediately. This order was passed without any notice to the appellant. The order presumably was passed by an executive engineer.
Yes.
And not the chief engineer, who was only the competent authority to pass such an order. This submission of the learned counsel for the appellant was sought to be contested by Mr. Nath, appearing for the respondents, who submits that the power to take a decision in that regard was delegated to the executive engineer. Nonetheless, when the matter went before the courts, the learned single judge found no folly with the decision of the respondents in cancelling the contract with the appellant. But on account of various startling facts brought to the notice of the court by the appellant, namely the selection of a new concessionaire without indicating the portion of the work which was to be completed by him, and release of a huge amount of money
1.9.
towards the bill raised by such person, comma, an inquiry was directed by the learned single judge. Stop. Pursuant to the inquiry, comma, the allegations leveled by the appellant was found to be correct. First up, the respondents in its wisdom recalled the cancellation order and entrusted the balance work to the appellant only. By communication dated 7th of August 2025, asking the appellant to mobilize his resources and intimate to the respondents about the resumption of the work. Wait a minute.
Well, 7th of August, it was direction to the executive engineer, then 1980.
1908. Stop. The appellant now is in the process of mobilizing his resources and would respond to the and would make effective correspondence with and would make effective correspondence with the respondents regarding the date on which the work shall be resumed and perhaps completed. Thus, in view of such direction of the respondents, in view of such decision of the respondents, in trusting the balance work to the appellant seeks to withdraw this appeal. Permission granted. The appeal stands withdrawn. I have left it open-ended.
Good enough.
Nobody would be pinned down with any statement.
Our purpose is served.
Now, your purpose is served, they are also saved.
Yes.
Otherwise, we'll have to issue direction for issuance of notice to explain the disbursement.
He has been punished. His pension has been withheld. And the other assistant executive, his two increment has been withheld.
What is that? We are not concerned with the officer. We are concerned with the unjust enrichment of the contractor.
Yes.
Now, where is the recovery?
1.92 crore.
Leaving it all open.
Yes.
Mr. Nath, he is withdrawing the appeal. We are leaving it now. Otherwise, we'll be saddling suspending an executive engineer means nothing. He must pay 1.9 crores. Would he do that?
Steps have been taken, Lord. The steps are taken, Lordship.
So therefore, we would not like to continue with further. We are not monitoring it.
Correct.
Therefore, go away. Otherwise, if he had pressed this appeal, we would have done something.
No. In fact, the appeal already has become infructuous.
No?
Because
No.
the authority.
Appeal has become infructuous for one aspect of the matter.
No.
220. This is a continuation of 226. 226. There are several radial paths on which we can traverse.
That will do. Lordship.
Whether you do or you don't do, you are out of our sight.
Item 16.
My lord, in this writ appeal, my lord. In this writ appeal, my lord, we have.
Mr. Goswami, yes.
It was earlier also taken up by your lordships, my lord. Two documents, my lord, they were.
No, we don't remember like this.
My lord.
You have to tell us some
My lord,
facts.
my lord. The writ petitioners, my lord, the respondents herein, my lord, instituted a writ petition in 2002, contending that they were selected for a post in Irrigation Department, and they wanted salary.
Which post?
They were appointed to the post of
operators in
My
the division of Irrigation Department.
Yes.
They were appointed when?
They were appointed on, my lord, 16/11/1999.
16/11/1999.
1999.
Now, they were appointed pursuant to any appointment process, any interview, nothing.
That's
But then-
why there was.
Just a minute. You allowed them to continue in service till how many years? 26
No.
years?
They never joined, my lord. They
They
never
never
joined. Yes, in 29/1/2000, my lord, within a month, my lord. Sorry, 16/11/99. Within a month, my lord, appointment orders were cancelled.
16/12/2099.
16/11, my lord.
16/11 is the appointment.
No, appointment is, sorry, my lord, 8/10/99 is the appointment. Sorry, madam.
8/10/1999, they were appointed. How many of them?
4 here, my lord.
4.
Originally 6, now before your lordship, there are 4 now. So those appointments were immediately cancelled on 16/11/99.
So therefore, not much delay.
Not
It was
delayed.
cancelled.
No, no, this order was never placed before this honorable court. In 2002, a repetition was filed by them.
Slowly, Mr. Goswami.
I'm sorry.
That I know all the facts.
I'm sorry, man. I'm sorry.
But we would not know the facts.
I'm sorry, man.
Then what happened?
In 2002, my lord, they instituted a writ petition contending that their salary should be released.
And they were not working, they were not marking their presence in the office, nothing.
No, not joined even, my lord.
They filed a writ petition.
Writ petition.
When?
In 2002, my lord.
2002.
Yes, my lord. That writ petition was disposed of in 2002, directing.
Disposed of or dismissed with cause?
Disposed of, directing to make a consideration of their claim. No merit, no consideration on merit.
Consideration of claim. All right.
No
Where is that order?
My lord finds that at 153, my lord. Page 159 is the order, my lord.
Let us see the beginning of the order. 153.
My lord.
Those days, orders used to be typed in a different way.
My lord.
Exactly similar in my.
4/3/2022, my lord. 2002. Last paragraph, my lord. I dispose of the writ petition with a direction that a certified copy of this order and a copy of the writ petition will be filed by the petitioners before a commissioner secretary to the government.
Then what happened?
Then, my lord, they instituted a contempt petition, my lord.
They instituted a contempt.
Contempt in 2003, my lord. That, my lord, finds at page 60. They, on their own, my lord, withdraw the contempt petition.
Contempt, where is that?
Page 160, my lord. Next page, my lord.
166.
Yes, my lord. They had withdrawn the contempt petition, my lord. Then, my lord, they did nothing, my lord. In 2012, my lord, sorry, in 2015, they filed a writ petition after, my lord, 13 years.
These four persons.
These four persons. They after 12 years, they filed a writ petition saying that in some other case, my lord, similar reliefs were granted. So they are also entitled.
Where is that?
On the basis of peri. That order, my lord, will find at, my lord, page 303, my lord. Here, my lord, on the only plea was, my lord, according to them, some identically placed persons also approached in 2002. They were granted this relief, my lord.
And where is that order by which, it was some relief was granted?
That order, my lord, finds at page 167, my lord.
Out fast.
So, my lord,
this was one of them.
No, some other persons, my lord. They say that we are
One of the appointees.
No, they are different appointees, my lord.
One of the appointees. I'm not talking about this case. We are talking at page 167 judgment.
My lord.
One petitioner.
My lord.
Abu Hussain.
My lord.
Not necessarily the respondent here.
One petition, only one petition was there, my lord.
No, my lord, 21 petition. 21 petitioners were here.
Oh, there were many.
There were many, my lord, yes. And others.
The first pair, sir.
Now, what was the judgment?
There, my lord, it said that they are entitled for salary.
Without working, without anything.
In that case, my lord, it was not a question that whether they were working or not. Only here, my lord, we have raised this point that they have never joined and they never worked, my lord. Page 205, my lord.
Against this judgment at page 167.
State preferred an appeal that was dismissed on the ground of delay. by this Honorable Court Division Bench. Again, SLP preferred, that was dismissed in limine, my lord.
But still, we will not do.
Then, my lord, my lord, preferred in the Honorable Single Judge, my lord, in this case, my lord, in the order impugned, my lord, directed them to allow to join and to pay salary, my lord. We caused an inquiry. If my lord, two documents, my lord, only, my lord. Honorable Single Judge order, my lord, finds at page 303, my lord. Only on the ground of parity, my lord. This order was passed.
Prima facie, per se, on
My-
ground of parity has to be accepted if the matter was accepted by the Supreme Court.
But they are not identically placed. Those petitioners, my lord, joined, they work. These petitioners never joined and their appointment was cancelled. That was not placed on record. It is our fault also, my lord. We could at that point.
Were their appointments were cancelled or not?
No. Their appointments were not cancelled. They
That's in
continued.
your favor. So their appointments were not cancelled.
That's what not continued. They continued. They are still continuing, my lord. But these petitioners were cancelled within a month.
So you filed a review.
I filed a review, my lord. In
Where
the
is that review order?
review order, page 306, it starts, my lord. The review order only on the ground, my lord. Though my contentions were recorded, my lord, the ground was that, my lord, there was delay in preferring a review. So
That's a good, again, a good ground. You
my-
are very
my-
slack, Mr. Goswami. Why is that?
in that, like, my lord, 2018 to 2021.
No, but
review.
then that is not there. They have said something about Uma Devi and Kesari and all that.
Yes, that was my argument before Honorable Single Judge. But finally, my lord, Honorable Single Judge, paragraph 12, my lord, may kindly peruse, my lord. At page 310. Paragraph 12 was my contention, my lord. Learned so and so, appearing for the appellants had firstly submitted that though appointments orders were
This is to be allowed. Yes, Mr.
My lord. My lord, firstly, lordship, in the impugned judgment, lordship,
The inaction of the state will not, will not persuade us to pass any order in your favor. All these orders we are going to stay. You have not worked.
lordship, we joined lordship, but we're not,
How can you join
lordship, we,
when your appointment has been cancelled?
no, lordship, our appointment was not cancelled, lordship. That document.
Are
learned
we
friend is
deciding
indicating
an
lordship.
oath against an oath? Our appointments are not cancelled, then they have no case.
Yes, my lord. My lord, firstly,
Where
I
is
come
the order
to
of
one point,
cancellation?
lordship.
page
Where is the
10,
order of cancellation?
page 105 and 150 and 151.
My
Those
lord,
are not backdated orders, no?
No, 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 my lord.
my lord, firstly, I want to come para 4, lordship. of
No,
the-
no, no, no. आपके सुनने से पहले we will try to
Yes,
clarify. If you have not worked, you will not get anything.
303.
We are not doing it. But we will impose heavy cost on the state for creating such confusion. In fact, if I remember correctly, this was what I stated on the last occasion.
My lord indicated 5 lakhs. My lord indicated 5 lakhs. I considered it as additional legend, my lord, 3 to 4 lakhs. Because, my lord, else, my lord, we have to make payment to these persons in crores who never join, never work, my lord.
Lordship may come to the order, lordship, 258. Cancellation order, lordship. I am directed to say that 6 numbers of persons have been appointed by Sri A. Rahman, former executive engineer, file office order number eligible, dated 8/10/99, irregularly without observing the required formality.
This is the direction for cancellation.
Yes, lordship. Then after that, next is lordship, appointment of 6 persons were cancelled. But who are the 6 persons?
Who are these 6
There is
persons?
no name, lordship. The enclosure is not also there, lordship. Enclosure as above. What is the enclosure, lordship? And lordship may come to
This
para
provides
4.
for something what was experienced in Alice in Wonderland.
Lordship, para 4, lordship, para 4.
Mr. Goswami,
My lord,
who are these persons? Whose appointments you cancel?
these petitioners, my lord.
How?
We caused an inquiry, my lord, after,
How? Where is this order?
my lord, from the date itself.
My
Very,
lord,
very pathetic.
my lord, in para
I
4.
mean, this is not a comment on you. It is a comment
understand.
on the functioning of
understand.
your agency.
I understand, madam.
We are not saying anything on you. Whenever we make such comments, don't take it
I understand.
personally.
I understand.
Now, the order does not specify whose appointment has been cancelled. There were so many. And they are getting their salary, they have joined, they are working.
Lordship, as their calculation, Lordship, they have cancelled 25
Tell
number.
me one thing. Have you been working on this file?
We are not working, Lordship. We not allowed. we are
When
not
did
allowed-
you come before this court asking you to be, to be reinstated in service?
So our first read petition is prior to 5580/2002, Lordship.
That has been.
Then, Lordship, contempt petition was, Lordship.
What contempt? It was considered, it was dismissed, so contempt you withdrew rightly. Some
Lordship,
good lawyer must have been there engaged. He
Lordship,
rightly withdrew the-
we withdrawn the contempt case just after passing of this judgment, Lordship. The similar judgment, 5580. Because furtherly, the respondents have given us certainty that along with them, your case will also be considered. When it is not done, Lordship, then only again we have come before this court.
Where is
Since
that inquiry
2002,
report, Mr. Goswami?
Page 219, after the Honorable Single Judge's order, my lord, we caused this inquiry. After that, my lord, we preferred the review, my lord.
219,
my lord.
9019.
219, my lord. After this report, my lord, we preferred the review, my lord.
But you must have an entry prior to that cancellation.
No,
We-
बाद में किया है।
We could honor cancellation order.
They had orally, they had said that we will resume, we will ask all of them to be taken in service.
If my lord peruses, my lord, second page, 220. The committee thoroughly,
We want us to go through this inquiry report.
and not,
We will again put you in dock.
not,
Look at this. During the inquiry, the committee did not find any record of opening of personal files in the name of the petitioners. Had they been actually appointed and joined service, personal files would have been op. This speaks badly of your housekeeping and file keeping. It does not necessarily deal with their lack of bona fides. You want me to go through this?
not entire, my lord. Only one paragraph, my lord, 221. 221, last paragraph, my lord, that paragraph will suffice, my lord.
You will be facing the Supreme Court now. After we pass an order, you will be facing Supreme Court. That after all this, also you were not careful. We will not grant them any relief, that is for sure. If they have not worked for any reason, we are not going to tell them after 26 years to be paid. But then you lose out because this matter will not end here.
Yes, sir.
And this will show your functioning. A serious matter. It's not as easy. It's a very serious matter which tells very strongly against you.
My lord, my learned
It is now, Mr. Can I have your name, Mr.
P.K. Das.
P.K. Das?
Yes, my
Mr. Das, now it is a matter between the court and the state.
lord.
You are.
But so I just like to one submission more, Lordship. There was an earlier inquiry, Lordship. In 2003, they have suppressed it, Lordship, not telling about this. There was an earlier inquiry about the illegality of those appointments.
What happened?
Lordship, the inquiry report, Lordship, is here, Lordship, at page 279.
Why do you have to keep it in such a, desultory manner? One at 100 page, one at 200 page. Collate all such information correctly. We will deal with it tomorrow.
My lord.
Just have the pull out sequence wise
My lord.
and give it to us. You need not file it across. In the registry, you will file it across the board. Tomorrow.
279, Lordship.
Tomorrow we will deal with it.
My lord.
Today we have little time, we have to rise. But have a separate pull out, Mr. Goswami, if you want any relief. Otherwise,
My lord,
very strong comments will come. Day of appointment, cancellation, their writ petition, whatever was ordered, withdrawal of contempt. Before the withdrawal of contempt, the writ petition of those persons. Several pages judgment by Honorable Justice Saha. Saha. You went against that judgment before the Supreme Court dismissed. You came here in the writ appeal dismissed. Thereafter, Supreme Court dismissed. An earlier inquiry, as Mr. Das is saying, and Otherwise, therefore, whenever you withdraw a case, you say that because of the verbal directions, verbal assurance given, we are withdrawing the content.
Right.
Or you should have asked the court to say that in view of the judgment by so-and-so in so-and-so, we are now not pressing the content petition because our grievances appear to have been redressed. I think we would have got into that. Simple withdrawal means nothing. You just now saw some petition was withdrawn, some appeal was withdrawn. They were careful in seeking an observation from the court. So give all these one after the other, right? And the first inquiry
Got
and
it.
the second inquiry.
My lord.
And then we will see what is to be done.
My lord.
Okay. Let this matter come up for consideration tomorrow. Just have a pull out, give separate copies.
My lord.